Lordship directed us to update this matter. Lordship, I pray this matter can be taken at 2 p.m. 2 p.m. Item 6061.
Please inform Mr. Sharma.
Well, yes.
May it please your lordships. With the consent of the other side, I beg to mention item number 26 on behalf of Mr. S.B. Prasad. He is not keeping well today. He is informed me that he is severely in bedridden condition. So kindly matter will take after a week, your lordships, as he requested, your lordships.
A prayer is made on behalf of Mr. S.B. Prasad, for an adjournment in the matter on the ground that he is in this. So prayer accepted. Registry to list this matter again after a week on a date to be fixed by.
Lordships.
Item number 40, my lord. Second day concern of other said maybe adjourn for today, my lord.
Why?
Because Mr. Mira is not
Huh?
here. Mr. Mira is not here. Mr. M. is there. So no.
Why? Mr. Mira, what?
Yeah, he
Out of state.
medical urgency.
Same.
Item number
Hey,
40,
Mira.
my lord. Oh, bless me.
May it please your lordships, I beg to mention item number 45. The matter has become infructuous, lordship. This is a contempt petition, lordship. The suspension has been revoked and this was first.
This matter.
Mr. Z. Hussain.
Respondent.
Yes, yes,
Mr. Z. Hussain.
yes. This is compliant.
Heard Mr. Z. Hussain, learned counsel for the petitioner. Also heard Miss
N.K. Sharma for
no.
UDAS, Lord.
Mr. N.K. Sharma appearing on behalf of Ms. Yudas. Mr. Hussain submits that the directions passed by this court, violation of which is alleged in the present contempt petition, has since been complied with by the respondents. So accordingly, he prays that the present contempt petition be closed. So, in view of the submissions made by the learned counsel for the petition, found that the order directions passed by this court have been complied with, the present contempt petition stands closed. Notices issued stand recalled.
Obliged, lordship.
Deeply obliged.
May I please your lordship, madam? Lordship, we have filed an additional affidavit on 3rd of June. Kindly call for the same along with item number 15, lordship.
You
15.
filed it in item number 15.
Additional affidavit. The day before yesterday, lordship, we have filed
For petitioner.
for petition. Yes. Much obliged.
Lordship, I beg to mention item number 4. It's the top of this lordship. Lordship, the matter has become infructuous. It's a 2019 matter, and the matter pertains to transfer, and it has become infructuous.
Mr.
U.S. Bora.
U.S. Bora appearing on behalf of Mr.
S. Bora.
S. Bora, senior counsel
Senior counsel.
for the petitioner, submits on instructions that the present writ petition has become infructuous, has been rendered infructuous during the pendency of the same. So, in view of the above submission of the learned counsel, the present writ petition stands closed as having become.
Lordship.
May I please, I beg to mention item number 25, my lord. In this case, my lord, I have praying 10 days time for filing rejoinder affidavit.
You have got your reliefs here. What more is required?
I have challenged the punishment part.
Okay, forget your rejoinder, make your submissions, we'll see. Forget the affidavit. You make your submissions on that alcohol fireman.
Yes.
You make your submissions.
Not rejoinder will be required.
We will ignore the affidavit, I'm telling you. I've ignored the affidavit of the government. Then what rejoinder? You make your submissions. We'll see.
May I please, Lordship? Lordship, for item number 34, we are filing the affidavit today. Lordship, may kindly grant us to bring on record the additional affidavit.
Call it, Lordship.
May it please your lordship. Taking consent from the other side, I would like to mention the item number 56 and 57 for adjournment. Your lordship, I am for the petitioner. The contending counsel is unavailable due to some personal difficulties.
Sir KP Maheshwari.
Your lordship, D. Rathi.
D. Rathi. Prayer is made on behalf of Mr. D. Rathi for an adjournment in the matter, account of personal convenience. So, prayer accepted. Registry to list this matters again after 4 weeks on a date to be fixed by.
Much obliged.
May I please, your lordship? Lordship, in regard to item 31, we're filing a
Item?
rejoinder. 31. We're filing a rejoinder today.
Why?
They said the same copy has also been furnished to the petitioner they have received.
You have filed an affidavit.
A rejoinder.
Rejoinder today.
Yes, lordship.
You are appearing for Mr. M.K. Das.
Yes, your lordship. For the petition.
A prayer is made on behalf of the learned CGC. CGC.
ONGC.
ONGC, Learned Council, Standing Council, ONGC. A prayer is made by the Learned Standing Council, ONGC, that and rejoinder affidavit. What rejoinder? You have filed an affidavit in opposition.
They have filed and reply in.
A reply to a reply.
Yes, they have filed their reply, so we're filing our.
Submitted that a further pleading has been brought on record on behalf of the respondents represented by him. However, the same is not on registry to list this matter again after
Summer break, Your Lordship.
3 weeks on a date to be fixed, along with the pleading stated to have been filed today.
Yes.
By the respondents. Number 2, 3, and 4.
Placed.
May I please, Your Lordship? Lordship, with the consent of other side party, I beg to mention item number 16, Lordship. 16. Lordship, the learned arguing counsel, Dr. A2D, could not appear due to medical condition of his mother, Lordship. Medical condition of his mother.
This?
Medical condition of his mother.
Mr. A, you are making this prayer on behalf of Dr. A.
A2D.
A prayer is made on behalf of Mr. A2D, Dr. A2D, learned counsel for the petitioner for an adjournment in the matter on account that on the ground that there is a medical emergency in the family. Prayer accepted, registry to list this matter again after 3 weeks.
Matter may be released on next Wednesday.
3 weeks. Next.
May it please, Your Lordship. Lordship, with the consent of the other party, I beg to mention for item number 38. 38. If the matter be adjourned and be listed after 3 weeks.
You're making this prayer on behalf of?
My name is there, Lordship.
Okay, Miss, why? Ground?
I am. Lordship, we need time to file our reply.
Reply. They have, ONGC has filed their affidavit.
Yes, Lordship.
Miss M. De, learned counsel for the petitioner, submits that she be granted further 3 weeks time to file a rejoinder to the affidavit filed by the ONGC respondents. Prayer accepted, registry to list this matter again after 3 weeks on a date to be fixed by.
Highly obliged, Lordship.
Please, Your Lordship, I beg to mention item number 24.
20?
Item number 24. I need take this matter on 8th of this month, Lordship.
Why?
We have filed an implement petition.
Get it, call it.
So,
Call it. Call it. What is there? You want 50% of your wages.
no, for inclusion of the petitioner legal heirs.
Oh,
Since
petitioner
the
is no
petitioner
more.
passed away.
No more.
Yes, Your Lordship.
Your name?
Bukha Chopi.
Mr. R. Chopi.
Bukha Chopi.
Bukha Chopi, learned W. Chopi, learned counsel for the petitioner, submits that interlocutory application for substitution of the legal heirs of the petitioner has been filed. However, the same is not on record. Also, he prays that the matter be taken up after week along with the said interlocutory application. Prayer accepted. Registry to list this matter again after a week along with the said interlocutory application filed by the said interlocutory application filed for substitution of the petitioner in the present proceedings.
Pleasure, Your Lordship.
Item number 8.
Heard Mr. Ayala, learned counsel for the petitioner. The present contempt petition has been instituted, alleging violation of the directions passed by this court-wide order dated 8/9/2025 in WPC number 6357/2024. Issue notice, returnable 4 weeks. Petitioner to take steps for service of notice upon the respondents by way of speed post. Steps within 3 working days from today. The personal appearance of the respondents at this stage is dispensed with. Registry to list this matter again after 4 weeks.
Obliged.
Sir, this is a contempt matter with regard to a judgment passed by this honorable court on 38/2023. Sir, there is one aspect.
Where is your explanation of delay?
Your Lordship, para 6 and para 9.
Paras?
6 and 9.
6 and 9.
Your lordship, the petitioner was suffering from various ailments, your lord.
That is no ground for contempt.
No, lordship,
That is no ground for contempt. You have to file it within 1 year. This court had in 23 August given you 2 months time. So that is October 23. So the time limit comes to an end in October 2024. You have filed it in 1 June 2026.
lordship,
You file a fresh petition. This contempt will not be maintainable.
lordship, may I then file an IF for condonation?
You can't. There is no provision for condonation of delaying.
That is also true, yeah.
You'll have to withdraw this and file a fresh thing for your
The only thing is that because of the medical condition.
have you taken your breakfast today morning? Then you increase your voice.
Your lordship, only thing is that owing to the medical condition of the petitioner.
Can't
he
help
was
it.
unable to.
Can't
do
help
that.
it. Can't help
That
it.
is why I
Contempt,
the
see section 20, contempt section.
Yes, lordship. I will.
Contempts of court act. Clear prescription.
Lordship, that is.
You withdraw it, I'll give you liberty to file, if required, file appropriate petition or something, or I'll dismiss it.
Lordship, then liberty may be accorded.
Liberty is always there. The learned counsel for the petitioner of Mr.
Yes, it, your lordship.
A. Setia, learned counsel for the petitioner. After attempting to argue the matter at some time, on being queried with regard to the delay in instituting the present contempt petition, the institution of the present with regard to the institution of the present contempt petition after 1 year from the date the violation of the directions passed by this court had occasion, submits that he be permitted to withdraw the present writ petition to file appropriate application with liberty to file appropriate application as may be advised. Also, they accepted present contempt petition stands dismissed on withdrawal with liberty as prayed for.
I live.
May I, your lordship?
Yes.
Lordship, matter pertains to non-payment of contractual bill, lordship. Page 14 is the liability statement. It's a admitted amount, lordship, and part payment already made.
This liability statement is of 8/1/2026.
Lordship. Page 14.
They have given you a lease of life.
Yes, lordship, that's what,
You have given them a lease of life.
that's what. Because they have done the work in the year 2012 only.
Heard Ms. K.K. Chaudhary, learned counsel for the petition. Also heard Mr. R.M. Das, learned standing counsel, Water Resources Department. The present writ petition has been instituted by the petitioners, praying for a direction upon the respondent authorities for release of a balance contractual dues amounting to rupees 22,57,983 for the works executed by her in the for the respondents. Also, the respondents, by issuing a liability statement dated 8/1/2026, has accepted the dues receivable by the petitioner. Also, in view of the issue notice returnable 4 weeks. Mr. R.M. Das accepts notice on behalf of all the respondents.
No, lordship, 327.
1 and 2 A guy.
Mr. Ms. A. Gayan, learned. CGC accepts notice on behalf of respondent number 1, 2. And Mr. R.M. Das, learned. Standing Council, Water Resources Department accepts notice on 3-2 for respondents number 3 to 7. Baki actually given. The respondents to file their affidavit on or before the next returnable date. So, registered to list this matter again after 4 weeks. Or take 2 weeks, right? For A Gayan to Likidibidi, CGC, Arbishon Arilas.
Kindly date may be given, Lordship. Lordship, on 13 July already, a similar matter is fixed.
It'll come.
Similar matter, Lordship.
Where is the liability statement here?
It's page number 14. A small amount, Lordship. Part payment already done. Lordship may direct them to verify and dispose of the matter.
Amount of rupees, yet it will change QDB, amount of rupees 124,547. It to item number 11. Baki ek case.
62.
None appears for the petition on call. For the ends of justice, registered to list this matter again after a week.
No, Your Lordship, I am agreeing for item 2, Your Lordship.
Yes.
Lordship, this matter pertains to Lordship.
Your name?
Of contextual due, Lordship.
Your name?
My name is Zia Abbas, Lordship.
J?
Zia Abbas, Lordship.
Yeah, okay, J. The heard Mr. J. Abbas, learned counsel for the petitioner. Also heard Ms. P. Thapa. No. P. Thapa, learned standing counsel, Panchayat and Rural Development Department. And Mr. And who is there?
Lordship, I am for respondent number 5.
And Mr. R.M. Das, learned standing counsel. Water Resources Department. The present petition has been instituted by the petitioner, praying for direction upon the respondent authorities to pay, to clear her pending contractual dues amounting to rupees 21.54,76 for words or legacy for execution of works under the for the respondents. Issue notice returnable 4 weeks. Ms. P. Thapa accepts notice on behalf of respondent number 1, 2,
4 and 6.
government to lagi hua tha. G Bokriya likhi divi. Ye upar utha. 1, 2, 4
and 6.
and 6. While Mr. G Bokriya, learned government advocate, accepts notice on behalf of respondent number 3, and Mr. R.M. Das accepts notice on behalf of respondent number 7. This is complete, huh? Registry to list this matter again after 4 weeks. Affidavit filed will be, huh? Last.
Deeply obliged, Lordship.
Obliged.
Kindly pass over the matter for the timing. My senior, Mr. KK Mohanto, is in legs, Your Lordship.
Today there is a big backlog, and we'll start dictating orders. There will be no time. Have it on Monday. Yes, Mr.
Otherwise, Your Lordship, the order that has been passed.
No, the order has been passed. It's fine.
It is in the teeth of Gorkha Security Services.
One,
my lords.
that is on technicality.
Mind.
On merits,
My instructions are, Your Lordship, that I had advised my clients to at least revisit this order because this order is otherwise unsustainable. The only reason they could not recall this order.
Bihar, an order was passed.
Yes.
And that was copy pasted.
But that cannot be done without giving them a notice. So, only reason that could not be recalled today, Your Lordship, is because the CGM, who is authorized to sign that order, he is on leave.
So
in fact, the meeting is going to be held tomorrow.
We'll keep it for Monday.
My lords, I'll have some instructions.
On the prayer of Mr. KP Pathak, Learned Counsel for the Learned Standing Council, APDCL, registry to list this matter again on Wednesday.
Very well.
On Wednesday. 10/6/22. You're getting it. What is it? Tell Mr. Monto to relax.
Oblige, Your Lordship.
Please, Lordship. Lordship, this matter is regarding non-payment of contractor's bill. Work order is on page number 20, Lordship, Annexure 3.
Annexure?
3, Lordship, page number 20. Page number 21 is completion certificate.
But Ms. Petal, the learned counsel for the petition. You are appearing for Madam All,
Yes, Your Lordship, all.
standing counsel.
Yes, Your Lordship.
So-and-so learned standing counsel. Also heard Ms. So-and-so learned standing counsel, Public Health Department. The present petition has been instituted by the petitioner, praying for a direction upon the respondent authorities to clear her his outstanding contractual dues amounting to rupees 1,96,806 against the work executed by him or the respondents. Issue notice returnable 4 weeks. Ms. So-and-so accepts notice on behalf of all the respondents. So no formal notice is required to be served. Registry to list this matter. 4 weeks affidavit to be filed.
Obliged, Lordship.
Obliged to Lordship.
Well, here my age is sorry, right shares my floated a tender my lord. And I become the my lowest bidder. A contract has been awarded to me, man. And my lord, work has been executed at the time of execution of one non-scheduled item. They allow me to execute the work.
But there are 3 communications, Mr. Chaudhary, wherein the respondents are saying
Yes,
that this is already incorporated in the BOQ.
yes, I want to show something, my lord. 203, my lord. First. 201, your lordship come. 201, first.
That is the BOQ.
This is the BOQ. Sub single partially galvanized. Next, my lord, 2.1, 421 for slip.
Where is schedule 2?
203, my lord. 203.
Schedule 2.
Yes, my lord. 203, my lord. Page 203, my lord.
Serial number 2.
2.1.
Construction of RCC foundation incomplete.
Yes, but next come, my lord. 2.1 concreting. 2.3 reinforcement. 2.2 is missing. 2.2 is missing. That is not in the schedule.
Might be a typographical error.
My lord.
Typographical error.
May coming, my lord. 2.1, 2.3. If your lordship come to the drawing, my lord. Next page, 206, 204. It is there tender, my lord. Left hand side, my lord. Concrete work, so-and-so, excavation 29472, reinforcement 9.
Where are you reading?
205. Is number for it.
That is a drawing.
That is the drawing. Left hand bottom, concrete, excavation reinforcement. Wherever in schedule that is not available, my lord.
Okay, relax up. But Mr. NNB Chaudhary, learned senior counsel, assisted by Mr.
PK Basu.
PK Basu, learned counsel for the petition. Who is appearing for the Miss R. Devi, learned CGC, and Miss K. Fukon. You are for?
6 and 7, your lordship.
Learned counsel, learned 6 and 7. Oh, AGCL, learned standing counsel, AGCL. So, issue notice returnable 4 weeks. Ms. R. Devi accepts notice on behalf of respondent number 1 and 2. While Ms. K. Fukan accepts standing counsel AGCL accepts notice on behalf of respondent number 6 and 7. So, no formal notice. Huh? Petitioner to take steps for service of notice upon respondent number 3, 4, and 5. By way of speed post steps within 3 working days from today.
Okay.
Ms. R. Devi and Ms. K. Fukan shall on the next date of listing apprise this court with regard to the contentions raised by the petitioner in the present writ petition, that the work excavation rate which he claims to be excluded from the BOQ of the work in question is required to be so incorporated therein. Also, further orders as would be mandated shall be so considered to be passed in the matter after the respondents. Learned counsel for the respondents have completed their instructions.
Wait, please, Dr. Malik. This is the third round of litigation, my lord. The last order, the reliant part, my lord, passed by this honorable court.
Yes, Mr. Sharma. There are orders from this court.
My lord, in fact, pursuant to the order dated 8/8/2025, there was an issue that had appeared, my lord, because there were a lot of petitioners similarly situated, my lord, that approached the offices of the IOCL.
So fine,
Thereafter,
whoever you approach, but there is a direction from this court in his favor.
My lord.
Then?
In fact, what had happened, my lord, in this aspect, we have sought instructions. The IOCL would provide cylinders to an agency. For example, the Uzan Bazar agency, madam. Now, upon verification of the cylinders, there are certain cylinders which will not fit the specifications. So those cylinders are sent back. Now, when it is sent back from the distributors, my lord, the distributor and the driver has to sign so as to there be a check and balances regarding the weight which has been sent back to the IOCL. Now, the entire aspect of the signatures of the distributor, the petitioner, my lord, and the drivers were missing. And there was a lax on our part also, because we had agreed to receiving those defective cylinders.
You had received those cylinders without any objection.
Yes, my lord. But there is a clause on waiver also, my lord, that one acquisition. But the fact is, my lord, that
once that cylinders have gone in,
my lord,
those cylinders are not numbered. You don't have a number of that now.
No, we don't. The issue that has happened, my lord, is that the signatures need to be present so as to give an accountability of the weight which is given back to the IOCL, and IOCL transmits that amount to the distributor. Now, distributor has nowhere negated the fact that they have not done their part of signing on the.
Okay, you forget your instruction.
My lord, we'll
file a
do that.
small affidavit.
We'll do that.
Let them file, my lord. I will show you, my lord. That is there.
Okay, Mr. Dr. Silatta, we'll consider. Don't worry.
And that signature is at the plant, not at sign.
Okay.
Yes, my lord.
No, they have verified, signed,
Mr.
check, my lord.
Silatta, we'll consider it. Don't worry.
Let them
Today,
file an
don't.
affidavit, my lord. Because, my lord, whole issue regarding the wrongful credit of the amount, my lord. That is the only issue, my lord.
Heard Mr. Siladitya, learned counsel for the petitioner. Also heard Mr. M. Sharma, learned standing counsel, Indian Oil Corporation. Issue notice returnable 3 weeks.
3 weeks, man.
3 weeks. Returnable on. Even pass now. We'll put it on 14th. 14/7, because last week is a motion day, motion week. So it may not be possible.
July 14th.
July 14th. Any problem?
Can it be on 17 or?
No problem.
15 or 16 or 17?
15, 16 also no problem. 15?
15, Lord.
15 on 15/7/2026. Mr. M. Sharma accepts notice on behalf of all the respondents. No formal notice, huh? Mr. Sharma Mr. Sharma submits that he would file an affidavit in the matter on or before 26/6/2026. Also, the petitioner may thereafter file a rejoinder thereto on or before 14 on or before 14/7/2026. Registered to list this matter again on 15.
There's an interim prayer, my lord, because they have already deducted 2 installment, my lord, despite the.
Any amount deducted from the account of the petitioner with regard to the issue involved in the present petition shall be subject to further orders that would be passed after the affidavit has been filed in the matter by the respondent.
I'm grateful, man.
Well, in fact, another matter is pending, my lord, with this court, my lord.
Yes, Mr.
Lordship. Similar,
Overnight, something happened
no,
that
Lordship.
you wanted to cancel it.
No, not like that, Lordship. Lordship, as per my.
What is the ground for cancellation?
As per my, which I have received over telephone, they want to add some more works in this particular tender because now they have developed some.
Where is your, that material?
Lordship,
Where is that material decision-making process?
Lordship may,
Where is the records?
Lordship may fix the matter on Monday. I will place the records, Lordship.
Mr. R.M. Das, Learned Counsel for the Learned Standing Counsel, Water Resources Department submits that the matter be taken up on Monday, on which date he shall. By Monday, they are not going to issue any tender.
Nothing.
By which date he shall place on record the reasons basing on which the tender in question was discharged. Also, pray accepted, registry to list this matter again on Monday.
Lordship, I will advise.
Only we want the reason, Mr. Hawk. That's all.
Yes, yes.
We get the reason. If it is valid, valid, not always not valid.
In fact,
But going by the plain reading,
yes, my lord.
No.
you get an order from this court the next night, they cancel the tender.
Yes, happening, my lord.
We'll see.
Lordship.
Fine.
May I please?
Why should we hear you, Mr. Pothakur, in this case? Why should we hear you in this case?
It is not a judgment, my lord. It's an order like, my lord.
Be that as me, you got notice. Why did you not appear?
We explain in paragraph 12, my lord.
Okay, let us see your paragraph 12.
And now we are going to take action, my lord. One board meeting is going to be held on 8th, my lord. My lord.
What steps have you taken against the sanitary inspector?
We are going to go to held a meeting, my lord, on 8th, my lord.
I'm sorry. This is not acceptable. Because this incident is of, the
Yes,
award
yes.
is of
Yes, man. I admit that there is some
31-26
mismanagement, my
and
lord.
the thing happened much prior to that. If he had not taken steps, why did you not take immediate action? You have not taken any action till
But we
even
are going to take step, my lord. My lord, kindly see, my lord, the award, my lord, how it is being.
Award, Karmacharis, now they are entitled.
No, my
They are
lord.
entitled.
My lord, it's a non-profit organization, my lord. 32.
If you had a objection with regard to the maintainability of the reference before the labor code, you knew that the matter
Yes.
was referenced.
Yes,
Was
I know,
referred.
there is some
You say that
mismanagement.
we are a state, so
No,
it is the act, it is the rules and
Therefore,
regulations
we
of
are
the.
going to take action against the hearing
Forget
officers,
it.
my lord.
Where is your challenge to that reference? Why did you not make a challenge to that reference itself?
Now, my lord, kindly see, my lord, whether this kind of judgment
Are you a
is passed,
state?
my lord.
Are you a state? Is the rules applicable to you? Have you adopted those rules?
No, my lord.
Then can it be automatically be applied? If that is not applied, that is the forum. And these people, they are the backbone of your organization.
Yes, I know, my lord. Now, my lord, kindly see page 148.
I'm not inclined to even say this.
Hello, kindly see, my lord, 148 is not a judgment, my lord. There is no determination of the dispute, my lord. Even if, my lord, but there is a judgment of the Kerala High Court, my lord. It says, my lord.
Persuasive value.
No, yes, my lord. But there is a reference of the Supreme Court, my lord. Kindly see for
I'll
a
give my
moment.
reasons.
Even
I'll
the,
give my reasons.
even if the CPC will follow, my lord, it says what is called judgment, my lord.
It is a spirit. This is CPC is not applied there. It's spirit.
But there has to be some determination of the dispute, my lord. There is no evidence, my lord.
When there is no dispute raised by the management, what more is required?
But in the conciliation proceeding and a meeting, we have raised our dispute, my lord.
No, what you said is we are going to implement, we are calling a meeting.
No, my lord. So
we are
far,
calling a meeting.
But-
We will do it.
but
We
so
are
far,
doing it tomorrow.
but so
We are doing it day after.
but so far the bonus is concerned, my lord, we have categorically stated, my lord, it is not applicable to the promotional, my lord, workman, my lord, because of the section 32, my lord. It's a non-profit organization, my lord, and a local authority is defined in Assam Municipal Act, my lord. It does not come under the payment of bonus act, my lord. Kindly see the for a moment the bonus act, my lord.
Well, presently main issue is for regulation.
But the state government has come with a act, my lord, which says, my lord, for provisions of which says, my lord, the person who are appointed, my lord, prior to 1/4/1993, their service can be, my lord, regularized, my lord.
My lord, after Sukhendu Bhattacharya's judgment on 29th of this May, my lord, I think everything has.
Oh, Mr.
Oh,
Vishwas.
yes.
Cool down. Have I said till now anything against you? Then why are you getting agitated? Yes, Mr. Bhattacharya is in trouble. Don't put him into more trouble.
Okay, there's an act coming to force, my lord. So for the employees of the municipal board, my lord. There is staffing pattern has been, my lord, fixed, my lord.
From when are these employees working with you?
But they have not given any cert, my lord.
Oh, you should know. You're paying them.
But 2019, my lord, some of our, my lord, listen to you. Some of I appointed on my compensation ground on 2018-19, my lord.
These are employees who are there in the normal cadre. You are provincializing. These people, you have kept them for 1,500 plus 50 rupees per day.
Yes, my lord.
We abhor this.
But we have given extra, my lord.
50 rupees. You
But
have given much.
beyond the minimum wages, my lord, per month, my lord. But for a more kindly see the payment of bonus, my lord. Section 32, my lord.
No bonus, of course.
We are paying more than wage.
Section 32, my lord. Nothing in this act shall apply to the, my lord, 4. Employees employed by an establishment engaged in any industry carried on by or under authority of any department of central government or state government or a local authority.
Show me that.
Yes,
It's an
local authority
industry.
defines my
Industry.
municipality act, my lord.
Where is the definition of
Yes,
industry?
yes. Oh, yeah, some municipality act, my lord. Section 3, my lord. 2, subsection 23, my lord. Section 2,
Some municipal
subsection 23, my lord.
2
subsection 23, my lord.
Empowered committee.
Oh. Sorry, my lord. No, 3, my lord. Sorry, my lord. Section 3, subsection 23, my lord.
Assam Municipal Corporation Act.
Yes,
22.
This one.
22.
And
There is a
1956.
new act, Assam Municipal Corporation Act 2022.
And 1956, my lord.
1956 is, I think, gone.
No, my lord. Top the my lord, amendment was there, my lord. It is there, my lord. It includes the municipal board also, my lord.
Yours is a municipal corporation or a board?
Board, my lord.
Board.
Yes. 323.
23, my lord. It includes, my lord, municipal board, my lord.
No issue. This is an industry set up by the board, which is exempted.
Municipality board is an establishment. I know, my lord, but
I know,
it has
but
to be applied, my
You
lord.
read the bonus act. Maybe
Yes, my lord.
read the bonus act.
My lord, kindly see preamble, my lord.
Forget the preamble. You come to the provision.
But that is the, my lord, core issue, my lord, whether it is applicable, my lord, whether it is a, my lord,
An act
profitable
to provide
organization.
to employees on the basis of profits on
Is
the
it
basis.
Only
So.
it applies only to, my lord, profitable organization. Not, it's not a, my lord, my board is not a profitable organization, my lord. And
There is
section
no payment of bonus in your organization.
no, my lord. Section 2, Section 1, my lord,
Okay.
kindly see.
For the time being, I'll stay that.
Yes, ma'am.
But with regard to regularization, no stay.
But somebody acts. But we cannot go.
We can't. You see Sukendu.
Yes.
But
So let us have
post the act, my
now
lord,
Assam
the-
government have to be
my kindly see this
review
section.
all the cases, my lord.
My lord, kindly
left now.
Section 50 of the Assam Municipal Act for a moment, my lord. There is a step pattern to be fixed by
We'll hear the whole matter
but
today
for-
itself.
No.
You argue, we'll hear.
No, my lord.
Now satisfy me. Why the conclusions are required when there is no objection from your end by the Labour Court? In spite of notice, you did not aware.
Yes, sir.
You waived.
Now, my lord, the procedure, my lord, which is followed by Labour Court is also, my lord.
You are not there, Mr. Bhattakur.
Yes, I know, my lord.
And you have not said that you have not received notice. You have got the reference.
Yes, my lord.
You have taken a plea that the reference is not maintainable. You have not assailed the reference before this court. Now the reference has fortified final logical conclusion. Those conclusions we
Now, my-
find to be genuine.
Even the Labour Court has done proceeded, my lord, illegally, my lord. Page 27, my lord, the application for adjournment for filing evidence on affidavit was rejected. Thereafter, you automatically, my lord, allowed to file affidavit, evidence on affidavit, my lord, without recalling the earlier order, my lord. There's a procedure less. I know, my lord, there's a mistake on our part, my lord.
You suffer now. The Safai Karmacharis, they are the
Yes.
lowest rung of the society.
That's
You
why, my
can't
lord,
exploit them like
but
this.
that's why this act came into force, but the stuffing pattern is fixed by the government.
Staffing pattern, I am hearing for the last 2.5 years, but I have not got what this staffing pattern exactly is.
But 144.
Every municipal case, there is a plea of staffing pattern.
But-
What is this staffing pattern? These people are working there. They'll have to be taken care of.
Earlier, but there is no stuffing pattern, my lord. What is the, my lord,
Mr.
Yes.
Biswas.
My lord, besides this judgment,
Huh?
besides this, we approached the Honorable High Court 2018. And Honorable High Court has passed an order for regularization of the matter.
I know.
They have not challenged that order also.
Oh.
Then ultimately we have approached the
There is
industrial
no,
tribunal.
not a direction like that.
Yes, madam.
My
Page
lord,
70,
Justice
my lord.
Yes, page 70.
Page 70.
Page 70. They have asked you to approach the
Yes,
authorities.
Yes.
Then there were some meetings wherein they gave you an assurance that we will.
Well,
take it
yesterday's point, yesterday, I had a talk because I am representing this since their birth of the, I am from Tejpur, the origin. There is no second man to look after their problem. But what happened? Yesterday, they were on strike from 3rd. And the deputy commissioner requested them the Lichu festival is coming from tomorrow. Kindly keep it neat, you have to take. Then I got a telephonic call. I said, you respect the deputy commissioner on the assurance that if their cases are to be considered.
There was a notice.
Yes.
For
Yes,
strike.
yes, I know.
Yes.
Second.
Yes, a strike is already, it has been withdrawn yesterday, my lord. I have, on my interview, I have asked them to withdraw.
Okay. We'll give a short notice. You also,
Yes, yes.
okay, we'll fix it for admission and we'll dispose it.
Yes.
Records are
My
required.
lord, only the pain is that
Records are.
we the people of Horijan, we born as a master role, we live as a master role and die as a master role.
Mr. Biswas, that is not required.
Very painful situation throughout the Assam.
That is not required. This court has appreciated your sentence.
Yes, yes.
Please don't go into the
My lord.
things which need not be gone into. Yes. Heard Mr. S. Bodhaku, Learned Counsel for the petitioner. Also heard Mr. S. C. Biswas, Learned Counsel appearing for the sole respondent. Also, issue notice returnable on immediately after the vacations.
Yes, madam.
On 16/7/2026. Also, Mr. As the sole respondent has been represented, no formal notice is required to be issued in the matter. Also, considering the submissions made by the Learned Counsel for the parties to the proceeding, this court is not inclined to stay the award in totality. However, the portion of the award pertaining to payment of bonuses to the members of the respondent union shall remain suspended till the next returnable date. However, this court clarifies the other direction passed by the other direction contained in the award is not interfered with by this court. Also, registry to requisition, to urgently requisition the records of the reference case number 3/2025 from the court of the from Labor Court, Assam, at Kamrup Metro at Gauhati. Also, registry shall ensure that the records are received on or before the next date of listing, before the next date of listing. Also, registry to list this matter again on 16/7/2026, on which date an endeavor would be made to dispose of the matter.
My lord, only one more. Pendants of the request shall not be barred to consider because they are going to have a meeting on 8th.
That I have said that I'm not interfering. Let them
They are file the execution petition also, madam.
naturally, they can. What is the bar?
Yes.
You don't go, you sit at home, big, your top shots, and then when the order is passed, you come running. That is not acceptable.
Obliged, madam.
One 22, your
Same order.
Lords.
We'll list it with Vilanka.
Lords.
Hey, Moirita, this is same order, right?
Lordship, our name may be reflected as,
By reflecting
21 and
all the cases, CGC.
CCC is there, BPCL and HPCL is also there.
BPCL is a party.
Yes. In item number
20 and 23. These are by
The earlier contract, my lord.
Karamveer is by IOCL.
Lords.
So it is similar order. Oh, it is some 21 to some. This tender is by whom?
Lordship.
IOCL. Then why are you all here?
Earlier they were,
The ATS arrangement, my lord.
Lords.
OMC, my lord.
Oh, that arrangement was
Yes,
with
but-
Yes,
BPCL.
BPCL, one HPC.
In item number 21. 21 is it with?
22, madam. Yeah, for madam.
In item number 22, my lord, the respondent number 7 is
No,
BPCL.
21.
21, I understand. It's entirely IOC.
IOCL.
21 is entirely IOC.
20 and
20,
22.
20, my lord, 7 is HPC.
20.
20 and 22, respond number 7 each, HPCL and BPCL respectively, my lord.
Okay.
20 and 22, my lord.
22.
22.
I think this is the app name, Kitchen Mate LPG.
It's seven.
BPCL. We are not going to write much. We'll only
No,
say
no.
this is covered, and with that, and we'll tag
True,
it.
madam.
Lords.
If your lordship also gives me the liberty, my lord, to file one consolidated affidavit, because the legal positions will be
So you
sequential
file one affidavit,
to cover
and you say it covers bill.
My lord, my
Why should I give you that liberty
My lord,
today?
my lord.
Why should I say Mr. Sharma should not bill for 7 cases?
Deeply obliged.
Anything more, or this is the end?
No,
End.
from my side. Obliged.
Yes, Mr. Agarwal.
Lord, your lordship.
Before you start,
My lords.
you take a sample.
My lords.
Before you send people, you have big inspections, you take samples. Now, once the material is supplied to the end destination, you take samples from them.
My lords.
How can you hold him guilty without even making him a part of that?
Precisely, my lords. My lords may have, I had a word with the respond with my clients. In principle, we have no objection to giving them the reports of the study. The issue is if your lordship has page number 60 of the petition, the tests were conducted because this is a project under the REC, your lordship. This is a company.
No, I got it.
Promoted by the government of India.
He has sent it to you in 101 and onwards drums.
My lords.
Now, you had yourself
My lords.
collected this material when it was before delivery at the location of
My
the
lord,
petitioner.
my lords,
Now it moves out of the location of the petitioner to the end user.
my lords,
When the matter is at the end user, you make further trial of samples and you send it to some NABL credited lab. You get some report. Now, there are two reports from NABL credited labs. One, the only difference between these two reports is, in addition to the variance, is that in one report, it was taken in the presence of the
my
petitioner.
lords,
The other one was not drawn in the presence of
my
the
lords.
Now, that plea of the petitioner that it was not drawn in my presence, although they have not hammered on that
My
in
lord.
the second letter, when you issued the second show cause notice,
My lord,
they have only asked for the reports.
my lords,
But they have not taken that plea, but be that as it may, that is a plea. What do you have to say on that?
my lords, to establish prejudice, if they are establishing prejudice, there has to be some materials on record.
No,
Your lordship.
but you
Only
say
mainly
you
because of the
come to
fact-
page 57.
My lords,
Mr. Agarwal, there was some noting here that you were given notices, but you have not
No,
appeared.
that noting, my lord, you will find in this second so cause notice,
yes, page 60.
second so cause notice.
Page 60.
But
Ah.
I have made a statement, my lord, in
Ah,
my,
you have made it.
I have made a statement my lord, in my petition.
If the reports are perhaps provided to them.
No. And whereas the contention raised by your firm so-and-so, 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 so-and-so does not hold ground as the sampling was carried out in presence of so-and-so, your firm was called upon to be remain present
My lords,
during the testing.
my lords,
So you also knew that their presence is required.
my lords.
But Mr. Agarwal, paragraph?
Paragraph 17, I have very specifically stated. Page,
Ah.
page 15.
So once this is there and you have not issued any notice to them,
My lords,
whatever steps you have taken, can you hold them guilty?
my lords, regarding the drawing of the sample, unless prejudice is established that
No,
by not
prejudice-
being present,
No. That very drawal of sample,
my lords,
they can say that we don't know from where you have drawn it.
but they have not said that, my lords.
Okay. But
So-
once you said, if they are given them a notice,
My lords,
in spite of that, they have not come, I would have understood.
my lords,
But this paragraph here in
My
page
lord.
60
my lords,
is categorically denied by the petitioner.
my lords,
So the drawal of sample from where you have drawn, because there is already an NBL report
my lords,
drawn by you, not by him,
my lords,
by you.
my lords. This second testing report was done, your lordship, at the behest of the REC. This is the respond number. Four. Now, why it had to be done at the behest of the respond number 4? Because finally they are responsible for the quality
I got
control.
it. If the quality, if there is something, some
lord.
doubt, you had already had a report.
My lords,
Maybe
my lord,
some bungling was done by the
My-
petitioner. We accept that.
my lord,
But when you're doing it, because you have to first confirm that this is the material of the petitioner,
My-
drawn from, that he will have to know.
my lord.
You say that you have given a notice, you show the notices,
Very well, your lordship.
get the notices on Monday.
Very well.
Till that time, no coercive action against the
Because
petitioner.
anyways, my instructions are that to take some coercive action against them, they have to be given an opportunity to file a proper reply, which they can only do if the reports are otherwise
No, we
provided.
are beyond the reports.
Very well,
Lord, may I draw another thing? Well, in this case, my lord will find, I am not the supplier. I am the manufacturer. Supply has been made by me, the respondent number 5, NK. And your lordship will kindly directly come to page 56 and extra 10. This is not there is no preview of contract between me, APTCL or REC or me, my lord. Your lordship will kindly see NK Power and Infrastructure Private Limited. Earlier, if your lordship kindly come to annexure 5, I'm just showing to my lord. My lord,
But
page
you are not the
34,
direct-
page 34.
Huh?
Page 34, your lordship. I'll just show to your lordship. My lord, your lordship will kindly see the
This is by NK Power.
NK Power, not by the.
But the
They are in the
No,
list
no,
of
no,
approved
no.
suppliers.
the initial testing was done in
Testing was-
your
In
your
my
process.
manufacturing process, my lord, both the testing were found. And the same 115 lot that was tested there in the NVR. And my lord will kindly see page 56 is very important. My lord, my responsibility is not there after the material goes. Page 56 down below, my lord. The dispatch clearance shall not.
absolve the contractor from his responsibility to replace the materials or make good of the defect defected during the inspection carried out in the line of the technical. But there is no preview of contract. Materials has been gone out from my manufacturing unit. You know what happened there, you know what material he has supplied, what material he has not supplied, you know, I do not know anything. And you know, your lordship rightly said that, you know, that 2 NABL reports. And you know, I have not been given the letter by which the
No, not, the second inspection, you were not informed.
Not
You have to be
not
taken. Okay, let him get that
Yes,
documents.
yes, sir.
We'll
Well,
have
in
it
the
on
meantime, you know,
Wednesday.
there should not.
There will be no action. Heard Mr. K. Agarwal, Learned Senior Counsel, assisted by Mr. G. Agarwal, Learned Counsel for the petitioner. Also heard Mr. K.P. Pathak, Learned Standing Counsel.
Respond numbers 2 and 3.
Standing Counsel, APDCL. So, Mr. A, in view of the deliberations that have taken place in the matter today, Mr. K.P. Pathak, Learned Counsel for the petitioner, submits that he would receive further instruction with regard to the following contention made in the communication dated 11/5/2026 by the Chief General Manager bracket PP Roman and D APDCL. The contention being relevant, following contention, the contention as made in the said order, said communication, second show cause notice dated 11/5/2026 is extracted here in below. Also, Mr. Pathak to place on record the basis for making the said contention in the said order by the said or in the said second show cause notice. Also, registered to list this matter again. When Mr. Agarwal, when it be? Monday week's time?
15th.
Monday?
15th.
If your lordship is having it for motion, then I can bring it on Monday.
Yeah.
10/6.
Huh?
10/6.
10 minutes, I will not be there.
12?
Then, no, then
15.
8. Let it be, huh?
8, 9,
तो नहीं रहेगा.
12 or 15 नहीं रहेगा.
So can it be on 16 or if not in
16, okay, 16/6/2026.
My
Till
friend
the
will-
next returnable date, no coercive action shall be taken.
Very well.
No coercive action.
Very well, very
against the
well.
petition. Because it's not the question of report now.
Very
Report will come if you can satisfy that you had given her notices.
Very well.
We'll dispose of this petition saying, give her the materials relied upon, let her make a details affidavit, let her reply, and then you proceed.
Very well.
But if there is no letter issued,
I understand what is.
your that ground goes.
Very well.
Then the whole
Or
thing will
I have made a specific amendment on.
para
all
17.
Very well. Deeply.
Lordship, my senior is on legs in court number 4. Can the matter be taken after some time?
Yes, Mr. Sharma.
Lordship. Lordship,
Who is your senior?
Miss B. Bhuya.
What is the stage?
Lordship,
Why this technical bit was not, sorry, financial bit was not uploaded in the site? They have to
Would have
upload.
been
And before
uploaded,
that,
was
in
not
terms of the condition,
Yes.
they have to inform you.
Yes, yes. Prior notice has to be given, Your Lordship.
What are exactly the deficiencies on part of the respondent number 4?
Number one, they are supposed to give the financial statements for 5 years. They didn't. They gave only for 3 years. 2 years they didn't give.
And that 8 lakhs was made 22
Exactly,
lakhs.
exactly. I'm mainly agree by that, Your Lordship. I mainly agree by that, Your Lord.
You are paying?
Yes, sir.
Yeah. How did you inflate 8 to 22?
Actually, morning.
Oh. You are for on caveat. You are on caveat. The allegation is that you had inflated the figures from 8, which is your original thing, to 22, which is the cutoff for participation in the tender. So you're ready, you know, we'll hear it. Let Ms. Bhuya come. Let Ms. Bhuya come.
Just I want to show you.
No, you read. I could read it. You could also now. You are giving you 1 hour time. Let Mr. Bhuya come. 2 points. 1. you have given for 3 years, not 5 years. 2, the inflation. 8.25 was the, it
And
went to
the
22.5. Any other point?
No, regarding the financial bid opening, that is
That's
not,
for
that is for the
Ms.
responsible
Bhuiyan.
party. That's
And
for the
Ms. Bhuiyan will apprise this court. 1, whether the notification was issued fixing the date for the financial opening. 2, when was the financial bid opened? And what is the stage? This 2 you get us by 12:30. We'll call it up. 12:30.
Not.
Tareva. Mr. Das, where is 52.1? 52.1?
Lord, I'll give this. I have given the book.
Up to defend excise law.
Page 24.
Page
24 of the Assam Excise Act 2000.
50.
52.1. It says about notice.
Where is the impugned notice?
There was no notice, my lord. Direct
No,
impugned order.
directly order.
Page 37, my lord.
This is passed by the magistrate.
District magistrate.
So this will be 52.1.
This will be 52.1, my lord.
So you say 52.1, there has to be a notice.
Number 1. And so far as the other part is concerned, if we go to 52.2 proviso, it provides, it's like, my lord, suspension review, my lord. It provides,
No.
because 52.1,
52.2 subject to correction would come in if this is passed by any authority lower than a magistrate.
fine, my lord.
And if it is a magistrate,
Even then,
1, a notice is required. Yes.
correct.
Lordship, as per my instruction, the petitioner was aware, your lordship. So as per instruction, no notice was issued to him in writing regarding.
Or we can say, I have borrowed money. I know it. So you don't know, no notice, no
There has to be a
departmental
notice,
proceeding.
your lordship.
Gone.
There has to be a notice
Then?
in writing because clearly
So
says by notice in writing.
We are keeping it in suspension.
I'll take the instruction, lordship.
I find the parties misplaced. Somebody is trying to open who does not want to open, and somebody is trying to close who wants to open. Now I find it very disturbing. Yes, what do we do? State.
Let me take the instruction, lordship.
2 o'clock.
Very well, lordship.
So you want these shops to be open?
A young boy, my lord, he has got
No,
something.
no, I asked you.
Oh, yes, my lord, it's a.
And Mr. Gogoi wants it closed.
Obliged, lordship.
Demand of the workman. Much obliged.
Obliged, lord.
2 o'clock.
Yes, ma'am.
Mr. Gogoi, if that procedure is not followed, ask them to withdraw it, follow the procedure and do what you want to do.
I can take the instruction within 5-10 minutes, your lordship.
No, no. We have more work to do.
Obliged.
You think Mr. Das is free? He'll have many matters.
Obliged.
My lord, I'm
Other than adjournment, anything.
I'm totally handicapped today because
Then
our
I'll
names
give you
are also
adjournment subject to payment of 50,000.
no
To
names.
the
are not-
lawyer's benevolent
My
fund.
lord, I have gone through the file, my lord. Lordship may dispose it of, my lord, to
I'm
examine
disposing it of with the direction that as the objections are not here, so he is deemed to be in service from that day with all back wages.
my lord, our names are not showing in the cause list. So we missed the matter and.
How did you know that this matter is there?
My lord, my friend, my lord, informed me, my lord.
Okay. Then today morning.
My lord, yesterday night, my lord.
Right. So you had the information.
My lord, sometime, my lord.
Fine.
Because
After 2.
the petitioner have a good case, I have gone through it, my lord. I can submit that, but some instruction, my lord.
2 o'clock.
Day after
If
tomorrow.
it goes beyond today,
after
it will
tomorrow.
be cost.
My
Mr.
lord,
Doctor, don't make me.
my lord, day after tomorrow, my lord. Because I am totally
coming on
overburdened today, my
I'm
lord.
not coming on Sunday. I have
Monday,
much
Monday,
work
my lord.
left.
Monday, my lord.
You have a
By
free
Saturday,
Sunday,
by
I
tomorrow,
don't have a
I'll
free
get my
Sunday.
instruction, and Monday, my lordship may have this matter. My lord. We take, my friend will serve a copy also, my lord.
We don't know. But Mr. J. Pine at some length, Mr. S. Dr. Learned Counsel for the Learned Standing Council PNRD submits that he would make his submissions in the matter on 9/6/2026. Registry to list this matter on 9/6/2026 for further hearing.
Lordship may direct registry to reflect our name, my lord.
By reflecting the name of Mr. S. Dr. in block letters as Standing Counsel PNRD block letter.
Small letters will work, my lord. Highly obliged, man.
Mr. Pine, you think you have a good case. Then why was this matter pending from 2017? For that we will penalize you. For that we will penalize you.
Agreed, Your Lordship. Lordship, this is a compensation of abatement matters. My lord, petitioner's father's died on harness on 9/4/2008, my lord. Thereafter,
Mother replied.
my lord. And
That why did you not pursue your mother's application? Why did you wait for 18 years?
My lord,
10 years.
Page number 22, my lord, if his application is rejected, my lord.
Whose application?
No, my lord, not application, but his not to recommended, my lord. Page 22, my lord. Serial number 3, my lord.
20?
Page 22, my lord.
Rejection. This is ekdam proper rejection.
My lord, same date, my lord, another applicant, my lord, consider his case, my lord.
No violation of Article 14. Have you made him a party? Have you challenged that?
No, my lord, I have annexed, my lord.
Illegality cannot be permitted to be continued with.
My lord, similarly situated persons, my lord, approached before this honorable court.
It may have approached. Is Devabrata Tiwari taken care of in those judgments? Mr. Upadhyay wants to. Yes, Mr. Upadhyay, you are considering. We'll dispose of the matter. If you are considering, not considering, then go to.
My lord, respondent also, my lord, not to file her affidavit.
Yes, Vajida, you know my orders.
My lord, same date, my lord, another person allowed, my lord.
Compassionate appointment, compassion must be here. But I don't find any compassion coming
It is
inside.
not mothers, my lord, immediately applied, my lord.
Should have pursued that. You should have come here. You waited for 10 years. And after 10 years, what is the compassion required? Compassionate
My
appointment.
lord, another order also, I have, my lord.
I have my own orders. I have my own orders. Done with? Sorry. Next time, better case. Heard Mr. L. Wajida, Learned Counsel for the petitioner. Also heard Mr. N. Upadhyay, Learned. Mr. K. Gugoi, Learned. Standing Counsel. Learned Additional Senior Government Advocate appearing for the respondent number 1. And Mr. N. Upadhyay, Learned. Standing Counsel, Irrigation Department appearing for respondent numbers 2, 3, and 4. 1 and 5, Mr. 8. The petitioner in the present, Ms. Wajida, please have your seat. In the present, the petition has prayed for a direction upon the respondent authorities. Has assailed the decision of the jurisdictional district level committee in rejecting the application of the petitioner for appointment on compassionate grounds on the by holding that the said application was filed after much delay, and at the time of the death of the father, the petitioner was aged only around 8 years. The petitioner has also prayed for a direction upon the respondent authorities for a fresh consideration of the case of the petitioner. So the father of the petitioner next, while working as a grade 3 employee in the establishment of the executive engineer, Silchar Mechanical Division bracket irrigation, had died in harness on 9/4/2008. Proximate to the time of death of the father of the petitioner, it is found from the materials on record that the mother of the petitioner had submitted an application for consideration of a case for appointment on compassionate grounds. As noticed by the DLC, the petitioner at the time of death of his father was aged around 8 years. Also, the application submitted by the mother of the petitioner on approximate to the time of death of the father of the petitioner is found not to have been pursued by the mother. So the family thereafter waited till the petitioner had attained the age of majority, and thereafter a fresh application was submitted by the mother of the petitioner on 12/12/2018, praying for appointment on praying for consideration of a case of the petitioner hearing for appointment on compassionate grounds. The said application filed by the mother of the petitioner came to be placed before the jurisdictional district level committee. The jurisdictional district level committee in its meeting held on 9/7/2019 considered the application submitted by the petition and rejected the same by holding as follows. Page 22, A to A. A perusal of the said conclusions are drawn by the conclusions drawn by the jurisdictional district level committee has been perused by this court. This court finds that the jurisdictional district level committee had rejected had noticed that the application submitted by on behalf of the petitioner was so submitted after around 10 years from the date of death of his father, of the government employee in harness. Also, further, it was found that the application of the mother, the application for compassionate appointment having remained made in respect of the deceased government servant, having remained unconsidered for more than 2 years, for want of 2 years, the same had spent its force. This court has considered the said conclusions are drawn by the district level committee and finds that the same are conclusions drawn German to the issue arising in the present proceedings, and accordingly, this court is of the considered view that the said conclusions would not mandate an interference from this court. Also, next, as noticed here in above, the father of the petitioner had died in harness on 9/4/2008. Also, the application, an application was thereafter submitted by the mother for appointment for consideration of a case for appointment on compassionate grounds, on 18/7/2008. The said application is said application submitted by the mother is not found to have been pursued by her, although it is projected that the petitioner's family was in dire need for a member of the family to be appointed on compassionate grounds to make the needs, to meet the ends of the family. Also, the latches, the non-prosecution by the mother of the application submitted by her for consideration of a case for appointment on compassionate grounds, and the long lapse of time occasioning before a fresh application was so submitted in the matter on behalf of the petitioner on 12/12/2018, this court finds that the immediacy as required to be followed in a matter of compassionate appointment stood lapsed in this present case. The claim made by the petitioner in the present petition is found to be a stale claim, and accordingly, this court would not issue any mandamus directing the respondent authorities to consider the case of the petitioner at this distant point of time for appointment on compassionate grounds. Bracket refer. There was the way to Tiwari versus and so. So, in view of the above discussion, the present petition is closed, is dismissed. However, dismissed. In view of the above discussion, the claim made by the petitioner in the present writ petition stands rejected. The writ petition is held to be devoid of any merit, and accordingly, the same stands dismissed. However, there would be no authorized to pass. Huh? Sorry, next time.
Oblige, your lordship.
My lord, the issue was, my lord, whether uncommunicated ICRs can be acted upon.
Mr. Pathak, two things.
My lord, no.
Two things.
One thing, my lord.
Uh,
This was pending, my lord, because
You have
the
given it.
matter
You have
was
given
in DB and DB has already decided, my lord.
Your lordship was there.
I decided.
Yes,
Yeah.
I forgot.
Jivan Singh, my lord.
I think I have made a mistake there. Oh, my order.
My lord.
Oh.
Meghalaya High Court had actually held otherwise, but an our DB, my lord, will be binding on us.
And when I am the author, I can't say anything.
Nothing survives, my lord.
Yes. I have done it correctly only. I have held against you.
My lord.
I thought I held against in your favor. That's why I
No,
said
no. We argued on the basis of the Meghalaya DBs as well.
I
But
remember.
then lordship has distinguished it.
Heard Mr. B. Pathak, learned counsel for the petitioner. Also heard Mr. S.K. Medi. You want to argue?
No, my lord.
No. Why? Argue. S.K. Medi, learned CGC appearing for the respondents. Mr. Pathak fairly submits at the outset, fairly submits that the issue arising in the present petition is already covered by the decision of the division bench of this court in the case of Jivan Singh versus Union of India and others. Bracketed judgment and order dated 4/10/2024 in W writ appeal number 277/2022, wherein the division bench of this court he submits that the division bench of this court had, considering a similar issue, held that the decision of the the decision of the Service Review Board.
Hello?
It will be a Service Review Board here.
Service Review only.
Service Review Board. That the employee was not fit, that the personnel of the force was not fit to be retained in the force beyond 30 years on completion of the prescribed qualifying service for pension, would not mandate an interference. He submits that in view of the decision of the division bench of this court in the case of Jivan Singh, the present writ petition would be called to be dismissed. Also, Mr. S.K. Medi, learned counsel for the petitioner,
Not
submits that
for respondent.
for respondent, submits that the issue arising in the present writ petition would be covered by the decision in the case of Jivan Singh Supra. So, in view of the above decision in the case of Jivan Singh Supra, the present writ petition stands dismissed. However, there would be no order as to pass. I forgot completely about this matter of appeal. Writ appeal number 277/2020.
I love this.
This is called fairness.
Yes, my lord.
What is left?
My lord, DCRG, some amount, my lord, and the leave encashment.
But they have made a statement in their affidavit that they have calculated all this in the scale of register. What do you have to say? But from a particular date.
Yes, my lord, that, my lord, I have made a arithmetical calculation, my lord. My lord, that lordship will be on page 61.
Yes, Mr. Dhor.
In 76, my lord, we have given a statement, my lord. That statement is there, how we have paid.
Page 61, my lord. My last basic pay is, my lord, 27120. If that is, my lord, last basic
You
pay,
have LTC, don't press.
my lord,
LTC,
That, my lord, they have.
you want to go by car, we
No.
don't get it. We don't get it.
No,
It's only point to point.
my lord, they have first disputed that it's Kalka, my lord, but subsequently when I made
You
RTI
may go
application,
to Kalka, you may go to Andaman, you from Andaman, Port Blair, you can go anywhere you want, but you will get the money till Port Blair.
Port Blair.
You
Point
won't
to
get
point.
beyond that.
but they have censored
You,
that part.
that
In
is up to you.
RTI, my lord, they have admitted that part.
Any admission beyond the rules, how can we accept? Now, what is the DCRG part?
And leave encashment.
Part. Only revision because of the scale of pay
Yes,
attachment.
Because there is.
Where is your statement that you made a statement somewhere that you have calculated all this on
Yes,
the
yes.
scale of
Page 21, my lord.
no. The statement of the
69, page number 69, my lord.
69.
Para 10. From, this is the entire money that we have given.
What do you have to say about this para 10?
My lord, that they have calculated.
No. They say that they have given because there was some registrar working till 31/12/2008, and you have been given. Why this? Why not from 1/1/2009, Mr. Dhar?
My lord, that is the
Where is your order of promotion?
My lord,
order of promotion.
Page 38, my lord.
3rd April.
Before that, lordship will find page 49. Order of this honorable court, my lord. Relevant page from, my lord, page 51. Page 51, my lord.
Page
51, my lord. Last paragraph, my lord.
by this time you had retired.
Yes, I have retired, my lord, 31/12/2008.
31/12.
2008.
Year salary to আপনার জিয়া হয়েছে
Area salary 99. Claim 9.
তথাপি আমি দিছো areas and pay allowances
80%.
হ্যাঁ 31/3 পুরা till retirement আর DCRG to
You were never promoted.
My lord?
You were never promoted.
no, not promoted.
My
You
lord,
were allowed to hold the charge.
because the earlier, my lord, who is
Fine. Where is the order of promotion?
that
Here also it
is-
says,
it is
this
page
quotes-
38, my lord, in the last part.
This order says that there is no need for creation of any post.
My
Without
lord, that is
creation
the
of post,
because
that means there was somebody already
because
holding
lordship will find page 38, my lord, last part, my lord.
38.
Yes, last, my lord.
Hmm.
Fifth line, my lord. Thereof, Sri Sovereign or Superintendent Office is hereby temporarily promoted and all to office at register.
Notionally to the post of superintendent. Notionally superintendent. Register. Allowed to promoted and allowed. So
And
promotion is
page 42, my lord, lordship will find.
cancellation.
The sanction part is also there, my lord.
What is 41?
41, my lord, that has been revoked, that order, earlier order.
It
And
was removed on
my lord, 18 June 2008. And 42, because there is a single post registered, my lord, that's why.
register post is 1.
Yes.
And the person who was there,
Yes.
he continued till
Because the earlier order, this honorable court that lordship will find in the page 35, my lord, that his service, this honorable court directed not
he
to
was
service. Page 35. That's why the, my lord,
10.
subsequent revocation order has passed.
okay. No. When did the Sixth Pay Commission came into effect? From 1/1/2006, 1/4/2006. Mr. Thor, some error in your this para 10. Because the Sixth Pay Commission is 1106, not 1108. 110 March or April, the notification came. It was with retrospective effect. So he's entitled. Mr. Hattilana Council for the parties at Samling. Mr. Thor submits that he be granted a week's time to complete his instructions with regard to the contentions made by the respondents in para 10. In para 10 of the affidavit filed by the respondents, it has been projected that the petitioner was authorized an amount of rupees 3,22,690. However, he was not entitled to the said amount as he had retired prior to the taking into effect of the revision of pay rules 2010. 2008.
I retired in 8.
You retired in 8.
The
And revised pay
is 1/1/2006.
Yes.
Sixth pay commission is 1/1/2006. With regard to the statements made in paragraph 10.
we cited 149.
I'll check up. I forgot that. I'll check up. Registry to list this matter again on 11/6/2026 for further hearing. You just check up
Yes,
that,
yes,
that aspect of the matter.
Yes,
Mr.
yes,
Thor,
yes.
you also just check up.
I will also check.
Heard Mr. S. Hawk, learned counsel for the petitioner. Also heard Mr. P.S. Vatsaji, learned CGC. The petitioner in the present writ petition has presented a challenge to an order dated 25/3/2013 issued by the Commandant 60 Battalion CRPF imposing upon the petitioner penalty of
Dismissal from service, my lord.
dismissal from service As projected in the writ petition, the petitioner, while discharging duties as constable with the 60th Battalion of CRPF in the state of Jharkhand, he had proceeded on leave to his native village situated in the district of Borpeta, Assam, with effect from 27/9/2011. The leave of the petitioner was so granted till 10/11/2011. So it is further projected that the petitioner, after reaching home, had been affiliated with various ailments for which he had to remain under constant medical attention from 2011 to 2018. So, the petitioner further contends that due to his prolonged illness, he was not in a position to resume his service nor send any communication to his battalion. So, the petitioner projects that in pursuant to an ex parte departmental proceedings instituted against the petitioner, after declaring him to be a deserter from the force with effect from 11/11/20 to 2011, the petitioner was, while the impugned order dated 25/3/2023, dismissed from service. So, the petitioner further projects that on a receipt of the said copy, and after being declared to be physically fit by the doctors attending on him, he had submitted an appeal before the Director Inspector, before the DIGP CRPF Gauhati range in the month of November 2018.
Date not mentioned, my lord, in that. It's November.
I am saying from the writ petition only. So, the said appeal was rejected by the appellate authority by holding that the same was so preferred beyond the period of limitation prescribed. The petitioner thereafter submitted a revision petition before the revisioning authority on 25/2/2019. They said revision petition was also dismissed while order dated 13/4/2019. Also, being agreed, the petitioner has instituted the present writ petition. Mr. S. Hawk, learned counsel for the petitioner, by reiterating the facts noticed herein above, has submitted that the petitioner was under treatment, after he had reached his native place by availing leave with effect from 27/9/2011, and accordingly was not in a position to contact his unit authorities and inform them about the reason for his absence. He submits that the petitioner, on regaining his health and being declared to be physically fit by the doctors attending on him, had taken steps against the ex parte departmental proceedings instituted against him, leading to the issuance of the impugned order dated 25/3/2013. However, he submits that the appeal as well as revision petitions preferred by the petitioner were rejected by the respondent authorities without even considering the contentions raised by the petitioner therein. On a query raised by this court, as to whether the show cause notice, the show cause notice, notice with regard to the holding of the inquiry as well as the inquiry report was furnished to the petitioner. Mr. Hawk has fairly submitted that from the appeal so filed by the petitioner as well as in the revision petition, there is no mention that the petitioner had not received the said documents. Mr. P.S. Bachchaji, learned CGC, appearing for the respondent, submits that the respondent authorities had, after declaring the petitioner as a deserter, comma, in terms of the decision of the Court of Inquiry, comma, instituted a departmental proceeding against the petitioner while issuance of a memorandum of charge dated 19/9/2012. He submits that a copy of the said memorandum of charge was sent to the petitioner at his residential address as disclosed in his service records. He submits that the petitioner did not respond thereto. So the show cause reply to the memorandum of charge not being received, written statement from to the memorandum of charge not being received from the petitioner, comma, the respondent authorities proceeded to direct for holding of an inquiry in the matter. The inquiry officer, on entering into the inquiry, had issued notices to the petitioner requiring his presence before him. It is contended that the said notices were also not responded to by the petitioner. Thereafter, on conclusion of the inquiry officer having submitted his inquiry report, a copy thereof was also forwarded to the residential address of the petitioner. However, the petitioner also did not respond thereto. So, Mr. Bachchaji submits that in view of the said position, the disciplinary authority proceeded to consider the materials coming on record as well as the conclusions drawn by the inquiry officer in his inquiry report, and on being satisfied with the fact that the allegations leveled against the petitioner stood established from the materials coming on record in the inquiry, proceeded while order dated 25/3/2013 to impose the penalty of dismissal from service upon the petitioner. Ms. Bachchaji submits that the petitioner had been granted due opportunity to defend the charges leveled against him. However, the petitioner had not responded to the same. He submits that from the materials brought on record in the petition, it cannot be discerned that the petitioner was not even in a position to send a written intimation to his unit about the reasons for his absence. Mr. Bachchaji submits that in the event the petitioner was suffering from ailments, comma, he would have received a free treatment for the same at the hospitals of the force. However, the petitioner is not found to have even availed the said treatment. Accordingly, Mr. Bachchaji submits that the claims made by the petitioner in the present petition would not mandate any interference. I have heard the learned counsel for the parties and perused the materials available on record. The petitioner, on remaining unauthorizedly, remaining absent without any intimation, comma, a departmental proceeding, as noticed herein above, was instituted against the petitioner while issuance of an office memorandum dated 19/9/2012. A perusal of the charges framed against the petitioner would reveal that he was alleged to have disobeyed the orders of the superior authorities and was negligent in performing duties, whereas inasmuch as he was unauthorizedly absent from duty with effect from 11/11/2011. It was further alleged that the notices issued, the notices issued to the petitioner requiring him to report for duty was also not responded to. So, as noticed herein above and fairly admitted to by the learned counsel for the petitioner, the notices issued, the show cause, a copy of the show cause notice memorandum of charge was forwarded to the petitioner, and he has not denied a receipt of the same. However, it is found that the petitioner had not responded thereto, nor intimated the unit officials about the reason for his absence from duties. This court has perused the medical reports brought on record, and from the said reports, it is not found that the petitioner was even incapacitated from sending a written intimation either by himself or through his family members to the unit, highlighting therein the reasons for his absence from duties. So the inquiry officer next. The inquiry officer on entering into the inquiry is found to have also issued notices by way of registered post to the petitioner, requiring him to be present in the inquiry. The said notices have also not been denied to have, they have not been denied by the petitioner to have been not, the said notices have not been denied. The receipt of the said notices has not been denied by the petitioner. The non-appearance of the petitioner in the inquiry had naturally led to the inquiry officer proceeding in the inquiry ex parte. On conclusion of the inquiry officer submitted his report and therein held the charges leveled against the petitioner to be established. The disciplinary authority of the petitioner on receipt of the inquiry report had forwarded a copy thereof to the petitioner. The petitioner has further not denied a receipt of the same. However, it is found that the petitioner had not submitted any representation against the said inquiry report. It is in the above background that the disciplinary authority, on consideration of the materials coming on record in the inquiry, as well as the inquiry report, as well as the findings recorded by the inquiry officer in the inquiry report, proceeded with the impugned order dated 25/3/2013 to impose the penalty of dismissal from service upon the petitioner, along with other consequential denial of benefits, service benefits. This court has perused the order dated 25/3/2013, has perused the inquiry report submitted in the matter by the inquiry officer, as well as the report dated, as well as the contentions raised by the disciplinary authority in the order dated 25/3/2013, and this court finds that the same, the conclusions drawn therein are being so drawn basing on the materials coming on record in the inquiry, which are to be held to be legally admissible evidence. So, the non-cooperation of the petitioner in the inquiry has established a proposal. But the petitioner in the present writ petition has also not brought on record materials to justify that his absence was for reasons beyond his control. And accordingly, the set period of absence cannot be deemed to be unauthorized absence. So, it is a settled position of law that a period of absence cannot automatically be held to be unauthorized, inasmuch as it is for the delinquent to establish that he had to remain absent from duties for reasons beyond his control. In the present case, we find that the petitioner had not taken any such steps to explain, to demonstrate before the inquiry officer that in the inquiry that the reasons for that he had remained absent from his duties for reasons beyond his control. Accordingly, the conclusions drawn by the inquiry officer that the period of absence of the petitioner was clearly unauthorized would not mandate an interference from this court. It is to be noted that the petitioner is a member of a discipline force, and his such conduct would not warrant his continuation in the post, and accordingly, the imposition of the penalty of dismissal from service upon the petitioner after conduct of a due departmental proceeding on the ground that the petitioner was unauthorizedly absent for a long period of time, not being justified by the petitioner to have been so drawn perverse to the materials coming on record, this court is of the considered view that the disciplinary impugned order dated so and so passed by the disciplinary authority would not mandate any interference. Accordingly, in view of the above discussion, the present writ petition is held to be devoid of any merit, and accordingly the same stands dismissed. However, there would be no order as to go. Sorry. Tablet.
That's we can do.
Now we allow it.
No, that's why Lordship will give us some time, my lord. Any day next week, because this will have a larger ramification.
No,
Another week,
everything is
Clerk
open.
Yes.
I'm
my
just
lord, that-
waiting to pass that order.
We are also, my lord, apprehending that such orders will come now. Because, my lord, the capping is, my lord, 1499 is free, otherwise.
Otherwise, they are covered here.
91.
I also cover it.
Oh, Mr. Chaudhary, we don't like to trouble you. That's why we have taken the trouble on ourselves. Have you read that Sukendo's judgment?
Yes, my lord.
There are 79.
No. Para 79
Is
is
the
I think
final
with
direction.
regard to
Yes.
workshop.
No. 79 is, my lord, relates to master role.
Master.
What benefit is to be given, from which date it is to be considered,
Just a moment,
whom to be.
very short memory, na? Yes. And the case of Mr. Chaudhary's client would come in within
My lord,
4.
No, 4 and or 7 also, my lord. First 7 they will have to fulfill.
7 he has fulfilled.
Yes.
Then it will be 4.
This is.
In case of retired appellants,
retired.
they shall be granted no.
But it says very categorically appellants, my lord. In all the 1 to 7, my lord. Very categorical.
Supreme Court has laid down the law. It is for us puny judges to follow.
We will.
And we will follow with very great happiness now.
Let it be next week, my lord. At least we'll give some counter, my lord, to the now, my lord, considering the present situation. We'll try to, my lord. At least we can try.
You can do anything you want. I can't go beyond 79.
No, that's fine. Lordship's mind may change also, my lord.
No, I can't. I'll not change.
Then, my lord,
Because this is not my thought process now. I am following judicial discipline.
important thing is that in single bench I appeared that, my lord, Upenda's case. In Upenda's case, what single judge has said, my lord, that has been reiterated here.
And very, say, Mr. Goi, the beauty of this judgment is
My lord.
it has considered the entire factual matrix from the
Yes,
day
yes.
when this issue had
Yes,
for the first time.
That was very clear from Upenda's also, my lord. They have actually, my lord, everything was narrated in Upenda's also. That has been narrated here. Thereafter, my lord.
No,
law-
single bench. Single bench Upendas, that narration. Huh?
You have passed that judgment. Subsequently,
Then there was a complete discussion on that. And then division bench, this order came, be that as it may.
Yes.
It was there and we were following it. And now Upendas is gone.
Yes, that's same way, my lord, the minimum pay scale will go.
No, minimum pay scale, we will revert back to Jagjit Singh.
yes.
We'll go back to Jagjit
And
Singh.
even another judge, Prem Singh also followed. Prem Singh also, my lord, covered my case.
No, that's regarding regular.
This works as employee.
Oh, that my Lord Justice Nangaratna
yes,
MR Shah.
Yes, my lord.
My any day on a hearing the Tuesday, my lord. Just on that one, nothing.
Next Tuesday, I am not available, my lord.
Then convenient to the honorable court, my lord.
Some big bag has come, so he has to go. Big bag suitcase is packed.
No, my lord. I have to go to Pune to my daughter.
Oh, daughter.
Sorry.
When are you coming back?
After next week, immediately after that week, my lord. After 2019, I am available, my lord. 22.
Then we'll have to go to next because I don't want to trouble any court on the last motion, Devik. Let us have it on fresh after vacations on 14th.
Everything is in.
Let it be on 14, my lord. In the meantime, we'll clap.
No, Mr. Thing is,
today.
from 22 to 26, it's a motion week.
Motion day.
Motion week. As had the Lana Council for the parties.
They will find review application before the, my lord.
Oh, let them. Can we stop them? Can we stop them?
Yes, sir.
I'm giving them the longest possible rope.
Yes, sir.
Because once we pull,
Yes, sir.
the finance of the state would likely move.
Yes,
so let them have their time.
I think about the weaker section of the society. These people are grateful employee, my lord. They should think, my lord, government.
Why? The judiciary has already thought about them. The decision in Sukhendu has come. So it's only a question of implementation.
Yes, my lord.
Even that implementation is not recorded, it's automatic.
Yes, my lord.
We'll do that, Mr.
Yes, my lord.
Yeah, he's asked for a he's just got it.
Yes, yes, ma'am.
Let them
Yes, my lord.
also consider.
Yes, my lord.
Because the budget is still not prepared. So maybe they'll have to put this thing also inside now. Heard Mr. NNB Chaudhary, Learned Senior Counsel, assisted by Miss Huh? K. Day, Learned Counsel for the petition. Also heard Mr. B. Gogoi, Learned Additional Advocate, appearing for the state respondents. Mr. NNB Chaudhary has submitted that the issues arising in the present writ petition is covered by the decision of the Honorable Supreme Court in the case of Sukendo Bhattacharjee and others versus State of Assam and others. The box 2026 INSC 523. He submits that the directions passed by the Supreme Court in the said decision be also applied to the case of the petitioner hearing. Mr. B. Gogoi, Learned Additional Advocate General, appearing for the state respondent, submits that he be given some time to appreciate, to make his submissions in view of the changed circumstances coming into effect after the passing of the decision in case of Sukendo Bhattacharjee by the Honorable Supreme Court. So, as agreed to by the Learned Counsel for the parties, registry to list this matter again.
16, my lord, on the same week.
16/7/2026. For admission here. An endeavor would be made to dispose of the matter on the next. But Mr. Gogoi, no further time. Yes, madam.
Lordship, before I answer all the queries of the Lordship, I have got certain submissions to make. Whether the writ petitioner has got any locus to file the instant writ petition, he has made the assertion he's the power of attorney holder. No document as such has been annexed with the writ petition, my lord. As regards that he is authorized, whether his general power of attorney has been given or special power of attorney.
The affidavit, the bid was submitted by the power of attorney holder or by the person, by the firm. Who has submitted the bid? Mr. Sharma, who has submitted the bid?
The form.
The power, not the power of attorney holder.
By the power of attorney holder, representing the form. Representing the form.
Who is Dayal Das? Who is Dayal Das? Dayal Das is?
Page 155, the power of attorney I have annexed.
155.
Yes, your lord. And at 156, clause 6, I have the power to appoint the.
Okay, that is
Lord,
gone.
let us see, my lord. There is the clause.
And I have signed all the tender documents. I am authorized. In each page, your lordship will find the.
You are one of the JV. You are one of the JV partners.
There are two partners. I am one of them.
Lordship, apart from that, my lord.
That is gone. Then next.
That is gone, but there are certain stipulations they have to follow as per the terms of the Honorable Supreme Court's judgment, my lord.
What are these?
Lordship, that the power of attorney holder with that clause I need to see once I overlook that, my lord. Yes, clause of the power of attorney.
That for the time being, we keep it aside.
Yes, Lordship.
Now tell me, how did you notify the date for, where is the condition with regard to opening of financial bid in the?
Lordship.
Yes, Mr. Hawk, you have withdrawn from the case. You are standing there, that's why.
Clause 23.8, your lordship. At page
23.8,
at page 54. This is regarding bid opening and evaluation. 23.8 at page 54 is bid evaluation. Your lordship may come down straight to Roman 3. The employer shall inform the bidders whose technical bids is found responsive. I have shown mine is responsive. Of the date, time, and place of opening of the financial bid.
Yes, madam. How did you do this?
Prior to the lordship is to read 23.4, my lord.
23.4?
23.4. The employer will open all the bids received online, including modifications made pursuant to clause 22, in the presence of the bidders or their representative who choose to attend at time, date, and place specified in appendix in a manner specified in
Madam,
clause
this
20.
is with regard to opening of the bids, not the financial bid.
Lordship,
This is the technical.
whatever instruction I have received from the authorities concerned, now all are system generated, all online. Once it is open, everything like message goes to the participants, Your Lordship. It's online, Your Lordship. Offline mode has already gone, my
I
lord.
want to know that you are going to push that switch
Yes,
at a particular time.
yes,
When did you inform the bidders, the responsive bidders?
yes, Your Lordship, I have got the date to that effect.
And a notice was issued, uploaded, how it was done.
My lord. 2/3/2026 technical bid opening.
That we have no dispute. Financial bid.
26/5/2026 intimation to technical committee for technical bid evaluation meeting.
That is also
Yes,
not
gone.
done.
27/5 technical bid evaluation committee meeting, no, intimation to contractors for financial bid opening.
When?
27/5.
How was it given? 27/5/26.
Yes.
How was it given?
But later I have got, my lord, but later also issued to the client of my learned friend, Dayal Das, Jogesh Das. It is to inform you that technical committee has declared your technical bid as responsive, technically qualified for the work, improvement and so. Under Assam Mala order so. You are therefore requested to attend or send your representative in the financial bid opening meeting to be held on 35, 3 p.m. positive.
This is a notification dated? It's a
The
communication.
communication dated 27/5.
27/5.
Yes.
Yes, Mr.
No, I have not received. In fact, your lordship may kindly come to for that.
And he has made certain allegations against the private respondent.
Page
On what
544.
basis of his, on what basis, your lordship? Basis of the information, my lord. Just on surmises and conjectures, he has filed a writ petition, my lord. And he doesn't have the authority to do so, your lordship. Under the lordship, I will refer one judgment. Part of attorney holders, how far he can go, your lordship?
Page 554, your lordship. This is regarding technical bid opening, your lordship. 543 and 544. 543, your lordship will find the date as 27/5.
40?
43. 27/5. Like just now, it was submitted that it was opened on 27/5. But on the next page, 544, it was uploaded on 35. So technical bid opening was uploaded on 35, but there was no intimation regarding financial opening.
And financial opening was fixed on, madam, you just gave me a
35,
date.
Yes.
35, same day. Not possible, your lord. It was uploaded on 35, the technical bid.
Okay. Madam, how long will you take to file a rejoinder, affidavit here?
Lordship, as soon as letter.
Next week,
Lordship.
Wednesday?
Lordship, Wednesday.
Because the delay occasioning, because now the very credential of the private respondent is questioned.
Yes.
So you proceed with the matter, you process the matter, will not stop you, but don't issue the final orders till the next day. Just satisfy this court that he had the credentials, that's all.
Lordship, prior to that, may I submit 2 citations, my lord?
Locus paper over.
On the locus, my lord? Of the power of attorney holder.
That we are not considering. That you will keep it in your up your slip on the index date.
And
We are
your
just going to the meat of the.
Whether honorable court go into the decision-making process.
We are not going into the decision-making process.
My
We
lord.
are asking you, in your decision-making process, whether the petitioner is correct in saying that a person who had only 8.25 as his
Turnover.
financial turnover had inflated that to 22 lakhs. To make
Lordship,
him
with the
eligible.
basis, my lord.
With that as it may, he has brought it. You just get that thing. That is all. And where are the documents, Mr. to show that?
Lordship, yes, page 457.
4?
457.
And madam, these things are there in the website.
Yes.
After the bids are open, anybody can download. the bid.
exactly.
No, he has since his raised allegation.
No, he has
Base is, my
downloaded,
lord.
he has downloaded those documents from the website.
Yes,
These are documents of the bidder,
yes.
J.R. Pasha.
Both the bidders. There are two bidders. I
I mean,
submitted all of them.
after lordship, the tendering authority, my lord, the board will decide
Of course.
as to the competency or,
Only asking you
my lord.
whether this projection office, yes, where is that 8.25?
Page 457, your lordship.
457. Yes.
This is for the financial year 2023-24.
Hmm.
And in 23-24, at the last column, 1, 2, 3, 4, fifth column,
Hmm.
the figures of the previous year was given, your lordship. And for the year ended March 31, 2023, the revenue and from operation, that is the turnover, is given as 88, 8 crore 85 lakhs. This is the turnover. Then your lordship may kindly come to the next page, 458. Balance is searched from here. And the relevant portion, your lordship will find it 461. This is sales, which is turnover, your lordship. Same figure. Same figure. The top table, your lordship. The last column.
Sales.
For the year ended March 31, 2023, your lordship got it. The figure is same, 8 crore 85 lakhs. So my contention here is that admittedly from their documents itself, it shows that the turnover
And
was
where is the
8 crore.
certificate showing 22 lakhs?
Yes, your lordship, the turnover certificate and also two documents they have manipulated. Page 453. In the table, the third row, 2022-23. It is given as 22. I can also explain why they have inflated the thing, because as per the clause, the value should be 50% of the total tender value. And it 50% of total tender value comes to 11 crore odd lakhs of rupees. So they have inflated it to 22 crores. And to substantiate this, they have given only a single document, which your lordship will find at 485. This is the only document they have given where this amount is reflected, no other documents. 485, your lordship.
This is a balance sheet. It's reflected there.
This is balance sheet. How can it be for the year ended 31st, 2023? Either this is right.
23.
If this is correct, then the other document is manipulated.
No. Where is that other document?
Yes. As 458.
458.
Sorry, your lordship, at 457.
So 453 starts 22 lakhs 58 85 90 831. And you say, come to page 457, that is for the year ending
31st March.
31st March 2024. That is 1
But
crore.
the figure is for 31st March 2023.
Oh, that is in the right hand side.
Your lordship will find if your lordship see the figure, instead of 8, they have written 22. All other figures are also same coincidentally.
Now come to the where do you so that 22 lakhs you just shown me?
22. All other figures. Instead of the first
Where
8
is
is
that
22.
balance sheet?
485.
480.
This is one figure for 31st March 2023, and at 457 another figure for the same year.
480?
485. This is for 31st March 2023. Your lordship got it. The amount is shown as 22, then other figures are same. 8590831. Now, if your lordship may again come to page 457, same year, 31st March 2023. Now the figure is 8859081.
No,
Instead of
this is a return. If you come to page 485,
this is the
return filed on
profit and loss.
3923.
No, not return. This is the profit and loss account.
Okay, that's a part of that form 33 CD.
Yes.
So this is a return it's a part of that return.
Yes,
naturally.
Yes, your lord.
It was filed on 39/20/23. This is for 31/3/2023.
Yes.
39/20/23.
Yes.
So here sales is 22/85/90/831.
Instead of 8, they have overwritten 22 there. That is my contention, your lordship. Instead of the first 8, they have overwritten 22. And that is, they might have forgotten to overwrite in page number 457 and 461.
Okay.
Lordship, whether honorable court.
Yes.
Lordship, it's a disputed question of facts. Let them
Okay,
go to
okay.
civil court.
Yeah, we will have.
There
we
is
have the
overwriting.
dispute Now only he is there.
And your lordship, my
Private
pleading,
respondent is
one small thing. Today morning I got
Private
one thing, your lordship. I may hand it over, your lordship.
Yes, Mr. Hawk.
To show that
Oh.
now this is their GST return, your lordship. To show that 8 crore is correct, your lordship. Your lordship, the financial year is 2022-23.
Madam, you complete your instructions. We are having this matter on Tuesday. You also complete your instructions till Tuesday. You process, but don't make. But Mr. We are not issuing a notice also.
My lord.
Heard Mr. P.K. Sharma, learned counsel for the petitioner. Also heard Ms. M. Bhia, E. Bhia, learned standing counsel, learned senior counsel and standing counsel. PTC. Also heard Mr. S. Hawk, learned counsel, appearing for the respondent number 4. So, as agreed to by the learned counsel for the parties, registered to list this matter again on Tuesday, 9/6/2026 for motions. So, considering the projections made in the present writ petition, this court directs the BTC authorities to process the tender. However, no final order awarding the work in question shall be passed before till the next date of listing. So, Ms. Bhia and Mr. S. Hawk shall invariably complete their respective instructions on or before 9/6/2026 with regard to the issues raised by the petitioner in the present writ petition pertaining to the eligibility qualification of the respondent number 4. Just that much.
All disputed questions, manipulation, whatever, the figure and all this.
Oh,
I'll leave it to your lordship.
bring it that. No, this
My
is
lord.
correct.
My
Then
lord.
disputed,
My lord.
I'll say disputed. One-sided dispute cannot happen. Dispute will happen when both of you say
Yes,
this,
well,
that.
something, my lord.
Submitting with some basis,
But with
madam.
basis.
And you get me, whether it is 2280 or 80 only. Mr. Sharma,
Lordship.
if that contention is correct, then you are in trouble.
Another
You are
contention-
in trouble.
I got it, your lordship. Another contention is that they have not submitted the financial report as per
Oh, forget
5
it.
years.
That is for Miss Bhia to look into, not for.
Not satisfied. The terms and conditions is a mandatory clause.
But if the figures are manipulated, then yes,
Yes,
because the
they are manipulated.
eligibility.
They are manipulated. Just now I have submitted the GST document.
I document.
Let me have a copy also. I'll also verify with my department.
give a copy. And you give him a copy, writ petition today, now.
Today itself, I'll give.
Today.
Definitely. Highly obliged, your lordship.
You are here till 4:30. He doesn't remain it till 4:30. He goes by 2.
Within just the time required to photocopy. Obliged, lordship. Yes.
No, Mr. Hawk will be more interested to get the copy because the instructions plus the MI will also come.
Yes. Obliged, lordship.
Yes. Morning mention was made, I rejected. All of Pishot Matiba.
27.
Same.
Oh, yes, but he's worksers now. He was upgraded to worksers. And
Be that as it may, para 79 will cover.
No,
that second part is just a clarification, Mr.
Yes, madam.
It's just a clarification.
80 to nalage.
That is by heart now. That is just a clarification.
But they objected. Finally,
Oh,
court
oh,
said that
that-
you will have to apply before the authorities. They let them take a call.
Oh, no.
Pension part. Yes, very clear, my lord.
We'll consider
Yes.
you, we finish it up, but my view is, that is, initially when I first saw the judgment, I was under the impression, that
First part.
this
national
old
law.
habit of looking into the operative part first.
No,
Of
no,
an
I
advocate-
read it, my lord. In fact, my lord,
Mr. Gugoi,
78. very
no
clear.
advocate will start reading from the top portion. First
Yes.
is the operative part, what we
Lordship,
see.
proceed.
Same, I saw the operative part, I thought, okay, this judgment is only for work charge. Then in the night when it struck me, then I read, then I came, 79 will cover, you see. We'll see.
My lord.
As prayed for by the learned counsel for the parties, registry to list this matter again.
16. 16-6.
Huh?
16-6.
16/6/2026. 16/7.
Oh, sorry. 7.
16/7/2026, along with WPC number 399/2023.
My lord, I have another 3 petitions in the similar, my lord. They are
Oh, that, let it come.
obliged.
399/2022. Yes, why no affidavit? Hardywood, nobody is there.
PK Munir.
Oh, you have asked him not to come. Huh? Get him. Get Mr. Munir. You want your salaries? Get Mr. Munir. Because I can't catch him. I'll have to catch Mr. Munir only. Get him. Second half.
May it please your lord.
I always pleased. Whenever you are here, I'm always pleased. Yes, what to do now?
My lord, they said, my lord, can you see their affidavit in opposition, my lord? That one Kishore Kolita filed this affidavit in opposition. That is only a forged one, my lord. Because in my affidavit in reply, I have stated in paragraph.
Okay, the pleadings are complete.
Pleadings are complete. My lord, let the record may be called for regarding.
That
the-
is for Mr.
Yes.
Doctor to decide. It is submitted in that the pleadings in the matter is complete. Accordingly, registry to list this matter again on 16/7/2026
My
for
lord,
admission here.
including because there is a serious allegation against the Kishore Kolita. Let the record may be called for.
In the meanwhile, the relevant records be kept ready by Mr. S. Dr. Learned Counsel for the Learned Standing Counsel for Panchayat and Rural Development Department. Disputed questions have come in record.
My lord, not disputed question.
After vacation,
Because this is a.
You
very-
enjoy your vacations.
No, my lord, I am enjoying because I am not, there is an interim order, I am enjoying, but.
That's why I
but
said,
I-
continue
no,
enjoying.
no, I have already constructed 95%
Know
of the
that.
shop.
But
That is
you
why.
are protected now to that extent. Let's see finally what.
Interim may be continued.
Interim order was earlier to continue till the next date of it.
Much.
You are for Nazrul. Well,
Recently, I'm interested with this brief lordship.
Huh?
Recently, I'm.
last date also you were
no,
recently
no.
interested. Daily recent
I pray
interestment.
for.
They interest you in the morning only.
I pray for little accommodation.
No, little accommodation second half.
No, lordship, next week, any day, lordship. Next week.
Consider
On
this at,
Tuesday, lordship.
we have
Tuesday.
considered this at length Thursday. Only have to pass the order.
Ultimately, lordship, what I find, lordship, we had a disputed question of facts are involved. The section 29, as well as the full bench decision, the matter should go to the educational tribunal because he is saying my get of appointment is.
Who is provincialized? Nobody is provincialized.
Nobody is provincialized.
So both of you go before
Yes,
the
yes.
tribunal.
Then that's what the full bench decision says.
My lord, your lordship's earlier decision, my lord. They have tactfully avoided the my lord, your lordship's order and suppressing it, they obtain a stay order. Lord, as per that, your lordship's order, director passed the speaking order. They have challenged, but did not disclose the order passed by the your lordship's, my lord. Even in your subsequent pleading also.
That's not it.
It was not bring the court's record. In my affidavit, I said
You
everything.
make your submission second half.
It is not today, Lordship. I have not gone through this.
No,
fact
last
because-
time also we
No,
done
no,
this
last time my
matter.
learned friend says that this matter has been heard by this man, that's why matter has been adjourned.
I heard it
on-
at some length for further hearing.
On that.
You don't want to
I was
want
not-
this matter to be heard by
They,
this
they,
court.
are-
On that
they,
because I
they are,
was
they
not
are
the
dragging
counsel.
the matter, Your Lordship. Mal.
On
They
that
are
day, I
dragging the
was
matter,
not-
Malot. Since 2024, Malot,
Lordship,
it is pending.
On 27/2/26, Mr. Dekai, I remember you appeared in this.
No, no, Lordship.
No, not in
That
this
is a
matter.
different case, Lordship.
Oh.
That is dismissed, Lordship.
That is already dismissed.
Yes, Lordship. So, my Lordship, the director
why
itself.
Why I only remember your name always? Huh? Whenever I see a school matter, I
That
remember your name only.
issue, ultimately, that issue was also referred to the judicial tribunal.
And when it is so complicated,
Yes.
only Mr. Deka would be the person to
That
resolve.
matter was also in that case was referred to the judicial tribunal because the director herself is not confused. Two contrary order, 2013 and 2014.
One is by the IS also.
I asked that also in 2019. Thereafter, director in 2013. Then
What is your date of appointment?
Lordship, my date was from the initial Lordship 1997.
Now tell me, what is, okay. The issue is very narrow.
Oh, that's true,
If,
Lordship.
if you take it from 1997, you are in.
Lordship.
Huh?
1998.
98, 97, whatever it is, you are in. We say 97. 98 is your appointment against the leave vacancy.
Yes, yes.
So 97, you are continuing that certificate,
Lord.
which went to the police. Ah, then I'll tell you the facts. Don't worry. Then now tell me, you get an appointment in the normal sense in 2010.
14.
14.
14.
14.
My learned friend is also on the same day, 27/11/2014.
14. Now, whether your
14
that 97 to 2011 or 14 would
Yes.
be counted or not.
So, if you go by the initial date of appointment.
There is no appointment as of 97. 98 is
There are
also
some-
not an
this is why,
appointment.
Lordship, at the very beginning, I am saying that the disputed question of facts are involved.
Okay, there is
There
no
is certificates also,
Oh, ho,
walking
ho, ho.
certificate also.
Oh, ho, 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 ho.
I don't,
Mr. Deka, there is no disputed question here as far as this court is
but
concerned.
the authority till did not
Oh,
deny.
forget the authority. Now we are, it's before me, forget the authorities. Now tell me one thing. Where is your appointment? Just show me your appointment.
Formal appointment of one page 157.
157. When Mr. Deka is here, I should not know about the pages.
So,
He will
English
tell me
speaking,
immediately.
you also already referred the matter to the judicial tribunal.
Ah, So-
157.
this is a resolution of the managing committee dated so-and-so 27/11/2004, you were appointed,
Yes, yes.
right? This is your formal appointment.
Yes.
And where is Mr. Goswami's appointment?
Well, page
Just 159. Oh, no.
80, 80 Mal.
80.
Affidavit in opposition, Annex R.
So both of you came in 27/11/2004.
Malot. Accordingly, I joined, Samin, my joined on
29.
29. He also
joined
29. It is disclosed in the.
So,
this-
Mr. Deka,
Let's say.
both of you joined on
But I am
27/11/2009.
traveling by the order of 4th of September 2019 as well as 31st of 2000.
Where is that orders?
That Lordship, kindly page 195.
195.
That was also person to court's order, Lordship. Page 195.
Oh,
The inspector was speaking order.
oh, forget your inspector speaking order.
Then director order, page 202.
202.
202, 31st of 2013.
These are all problems created by the other sponsor.
Disputed facts, Lordship.
No disputed fact.
This-
No disputed fact.
Now, the full bench says, Lordship, well, the matter of regard.
There is no dispute.
Claim
We
for-
are saying dispute will not do. And this order is the correct order.
Had the authority, Lordship,
This is the
initially
correct order.
appointed in the year 2004, they
Right?
had
That is the correct order. That is the correct order.
31.
203. Director 29/7/24.
20, yes.
And that is what is under challenge here.
Malot.
No,
Right.
thereafter, that was Lordship,
Malo.
my learned friend put to challenge that order in.
203 is the correct order. Malot.
62.
That is under challenge.
So we have to only examine the validity of 203 and 204. That's all. Nothing more, nothing less. So we'll pass the orders at 2 p.m.
Lordship, next week, Lordship.
No, today.
Then my submission will
Forget.
no.
Why are you troubling this small brain with
My submission will be recorded.
I will record your submissions to
Matters will be
full.
referred to the divisional tribunal.
You have 1 hour, read. We'll have it at 2.
No, I have gone through. If
I
you
love
go by this order, Lordship, there is no Lordship dispute.
We will provide that if you have any further grievance in the matter, you go and institute proceedings before the educational tribunal. In the meantime, he can be provincialized, but that will be subject to any orders that would be passed. Finished. Because we'll hold that 97 to 2004, that period of service will not be recognized for the purpose of provincialization.
Although there is nobody forward, it is not denied by any authority.
We will now lay down the order.
Not today.
Come as a
On
substitute.
Tuesday, your Lordship passed the order. Lord, today, that I have some difficulty, Lordship. That is why. Otherwise, I will not make any such request, Lordship. Tuesday, your Lordship passed the order.
Get me emotional, huh? Third day parties at length. Registry to list this matter on Monday.
Lordship.
Monday. Dictionary hogo. Tuesday. Kali wonders, no? Tuesday. As a partner matter.
Lordship.
Mr. Goswami, Monday this file will again come back to me. I'll read. I'll come, might find out something against you now. You know.
As your last, please, Ismail.
Mr. Deka,
Lordship.
Tuesday.
Lordship.
So no new advocate should come in on Tuesday.
To Lordship, as my name was not reflected in the post list, Lordship, I somehow overlooked the matter, Lordship, and could not bring the file, Lordship. Please,
You're appearing for whom?
petitioner, Lordship.
On the prayer of Mr. Dole, learned, counsel appearing for the petitioner. Registry to list this matter again. After.
My lord, may I pray, Lordship, let it be after the vacations, Lordship. I have obtained the records, Lordship. I received the records. No
If you have
confidence.
the records, we will consider what is there.
Lordship, I will not be there, but that's why, Lordship.
Also. Prayer is not objected to by the learned counsel for the respondents. Also, as agreed to by the learned counsel for the parties, a registry to list this matter again on when?
Immediately after the vacations, Lordship.
14?
No,
14.
16, Lordship.
16 we have too much. 14. 14. Oh, we'll have it on 15 also. 15.
Lordship.
15, 6, 7, 2026. The records received by Mr. S.S. Roy be retained with him. So and so, reflecting the name of Mr. Dole as learned counsel for the petition.
Deeply.
Let's come back at 2. Yes, Mr. Sharma,
Yes,
what is your instruction?
My lord, as per my instruction, my lord, as per their rejection letter dated 27/5/2026, my lord. Yesterday they have filed that as per my lord, outstanding dues as on February 2026 stand 82,78,980. And my lord, in the month of March 2026, we have already paid 40,42,000.
No, total dues according to them is 1 lakhs 95,000.
As per my instruction, it is not correct. My lord,
Okay. Do one thing, why these disputed questions we should go into? You go before the civil court, establish your right.
My lordship, kindly go through that, my lord, that letter, my lord, 27/5, my lord. The last, my lord, clause 8, my lord.
After adjustment of the payments already made.
No, my lord. This, no, my lord.
27/5.
Yes, my lord.
As per duly audited,
no,
the
no,
total
as per
outstanding
duly
dues as on
audited-
February stand at 82,78,980.
Yes.
Your proposal fails to address and liquidate the matter. In view of the above, your proposal is not acceptable to us.
Yes, my lord.
So 82,78,000 is the
82 lakh
proposal.
78,000, my lord. It is as on February 2026. And my lord, in the month of March, my lord, we have already paid
Yes.
40 lakhs 42,660.
My lord, this calculation basis on the basis of adjustment amount, whatever that has been paid. Now,
No,
lordship,
this-
suppose this is a matter.
This is saying you would say till February 26,
My
but they made the payment in 40 lakhs in
That's why, my
subsequently.
lord, so far this figure is concerned, my lord. Suppose they are disputing that 50 lakhs they have paid. Then last occasion, lordship directed that so far the interim extension is concerned, they have to pay 30 lakhs. Rest amount, suppose whatever, that is a matter of.
So you have
suppose
paid
correct,
out of, you say out of this, you have paid 50 lakhs.
Yes, my lord.
So how much
No,
more
no,
you are
March,
paying?
in the March, my lord, 40 lakh 42,000.
Okay, how much are you paying now?
So, my lord, if we assume this calculation, then 42 lakh 36,000 is left, my lord.
Oh.
So, my lord, we are proposing, my lord, to pay in, my lord, monthly EMI, my lord.
Monthly impact.
My lord, I am paying on the basis of one, my lord, resolution, which was taken on, my lord, 3/4/2021, lord. So I have
This is a too old pending due.
My lord.
How much are you paying upfront now?
My lord, my lord, current rent, my lord, plus my lord monthly
My lord,
EMI,
may I make one question clear, my lord? This figure shows, because my lord, the letter was issued on 27/5/2026. Lordship, just hold.
Okay.
On February.
How much are you paying?
My lord, my instruction is that my monthly. My lord,
So you're
EMI,
not
my
in, we are not extending the interim order. Let them take whatever course.
My lord, up to 5 lakhs.
This is public property. There is nothing, you don't have any right on that.
My lord, let's kindly go, my lord, page 61, my lord. That our additional affidavit, my lord. Page 61, my lord. It started from 59. One meeting was held, my lord, between, my lord.
The period is over. You have defaulted, so they have rejected.
No, it is.
Now,
meeting never decided anything, my lord.
Mr. Samaria,
My lord, meeting was held on 2021, my lord. And lordship kindly.
Mr. How much are you paying? That much only we want to know.
My lord, my instruction is that, my lord.
Okay.
5 lakhs.
You pay 25 lakhs within a period of 15 days from today. We are extending the interim order. Rest we'll consider when the matter is finally heard. The organization has to suffer.
But my lord, lordship kindly place.
If you are not willing, we are not extending the interim order. You can't take advantage of a default on your part.
But my lord, that provision is there.
Mr. Sharma, you are aware that you have to pay a default. If you are disputing that, go before the civil court, get it settled. We are passing the order today.
But my lord, that EMI provision is there, my lord. Lordship kindly.
We are not concerned.
Page 61.
We are not concerned. What happened? Why didn't you do it from 221 then? You could have done it. You have not done it. You required this court's push to do that. Mr. Sharma, your client cannot take advantage of his own default. Will not permit. So pay 25 within 15 days, or on the closure of the 15 days, this interim order will stand vacated.
It is on to your lordship, my lord.
Or if you agree that you're not paying, we'll vacate the interim order today itself.
Well, lordship kindly give me an opportunity, my lord.
No opportunity. Opportunity already granted. Either 25 lakhs agree, or we vacate the interim order today. You go before the civil court. We'll dispose of the writ petition.
But I cannot undertake without, my lord, the.
We'll give you time. You come back by 3. We'll give you. Tinta bajat material. Yes, Mr. Gogoi, what did you get?
Lordship, can you peruse page 28, your lordship, Annex H. Department says that he has already put to notice, your lordship. Page 28, Annex H.
I can do it.
I'm sorry, this cannot be the notice.
That's my interesting, because he was
This
put to notice.
This cannot be. This is not 51. But this is with regard to that complaint. 51 says very clear. 52(1). District
52(1).
or subdivision magistrate may by notice in writing to the license require that any shop which any so and so shall be closed at such times or for such period as such the magistrate may deem necessary for the preservation of public peace. This is an inquiry.
Inquiry was conducted because his shop was closed.
No. Where is that notice that we are going to close it?
That notice is not there, Lord.
Or such period or whatever it is. There has to be a period mentioned.
Yes, that has a period mentioned, but as per my instruction, this note, he was put to notice since his shop was closed 14th. And 16, he was again called for a marital inquiry. And this inquiry is still pending, Your Lordship.
And you have not, where is the opinion then drawn? Where is the basis of this opinion that there would be a breach of public peace?
Okay.
Because the requirement again in 52(1) is for preservation of public peace. So where is the opinion drawn? Other than this, that there is a likelihood of breach of public
That's
peace.
speaking order at third paragraph, Your Lordship.
No. Your inquiry is not complete till now.
Inquiry is not, but because as per excise rules, Your Lordship, the inquiry is still going on. Yes, Lordship, but the district magistrate passed the order, taking in consideration the reports.
This district magistrate has passed this order.
Yes, Your Lordship.
As the district collector, excise collector.
Yes, Your Lordship.
This order is not as a deputy commissioner per se. This is as a, because he has the role as he is the head of the district excise collection district, excise.
Collector,
matter, he is the collector. So this order is as an excise collector. 52(1). So when he declares, he'll have to first say, let's say I'm going to close this for this reason. Then if he does not close, he will go and close. Is that the purport?
Sorry.
52(1), that is the purport.
52, Amila, I place his judgment, very beautiful judgment, Miller. Lordship will see how this honorable court interpreted. The power under 52(1) is not unlimited. Because 52(2) proviso also has got some bearing on it. Para 6 and 7. It's for public tribunals. Exactly.
I know this.
Then?
So it's
Mr. H.K. Das, learned counsel for the petitioner. Also heard Mr. R.R. Gauhati, learned standing counsel, excise department. Issue notice, returnable. How much time you want?
3 weeks, Your Lordship.
3 weeks. Also, Mr. R.R. Gauhati accepts notice on behalf of
Respond number 1, 2, and 3.
1, 2, 3. You can take for the collector also.
Yes, the excess.
4 and 5, Your Lordship.
4
and 5.
Ms. M. Bhachaji accepts notice on behalf of respondent number
6.
What M. Bhachaji will. Also, the petitioner has prayed for an interim direction. The parties were heard at length on the prayer of the petitioner for interim direction. The petitioner in the present petition has projected that on a IMFL on license being issued to him on 11/5/2026, after completion of the prescribed formalities, the petitioner started his business on 13/5/2026. On 14/5/2026, some people had gathered in the vicinity of the petitioner's IMFL apostrophe on establishment and had started a demonstration demanding closure of the same. Also, the excise officials on reaching the said place, the co-district commissioner, Bilasi Para, that is the respondent number 5, who had appeared at the premises of the petitioner's establishment, verbally instructed the authorities, excise department authorities, to present at the site to shut down the shop. Also, basing on such verbal instructions, the shop was closed down by the authorities, and the key is projected to have been taken away by the jurisdictional excise inspector. Also, the petitioner on 15/5/2026 submitted a representation before the co-district commissioner therein for reopening of his establishment and for smooth conduct of the operations thereon. Also, thereafter, the petitioner on 16/5/2026 was issued with a notice requiring him to appear before the Assistant Commissioner cum Executive Magistrate Bilasipara in connection with a magisterial inquiry underway in terms of complaints received from various organizations with regard to the opening of a wine shop, about opening of the IMFL on establishment of the petitioner at support. The petitioner projects that he had appeared before the said authorities. Also, it is in the above background that the petitioner thereafter projects that he had approached the district commissioner, Dubri, praying for permitting him to continue with his business by permitting him to reopen the IMFL shop on by IMFL apostrophe before on stop. Also, it is in the above background that the petitioner had received an order dated 29/5/2026 issued by the district magistrate Dubri, directing the petitioner to directing temporary closure of the IMFL on shop of the petitioner on the ground of preservation of law and order and public peace. Accordingly, it is only on 29/5/2026 that the petition, that a formal order for closure of the IMFL apostrophe on shop of the petitioner was so issued. Also, a perusal of the order dated 29/5/2026 would reveal that the same was so issued by invoking the powers, by invoking the provisions of subsection 1 of section 52 of the Assam Excise Act 2000. Also, this court has perused the provisions of subsection 1 of section 52 of the Excise Act 2000. On a perusal of the said provisions, this court finds that the district magistrate or a subdivisional magistrate is empowered to require any shop in which any intoxicant is sold by retail to be closed for such times or for such periods as the magistrate may deem necessary for the preservation of public peace. However, what is to be noticed is that the said provision mandates such magistrate to issue a notice in writing to the licensee for the purpose. Mr. H.K. Das, learned counsel for the petitioner, has placed reliance on a decision of a coordinate bench of this court in the case of Manik Kumar Roy versus State of Assam and others, order dated 10/1/2022 in WPC number 5019/2020. So this court has perused the said judgment. Has perused the said order also. And in respectful agreement with the conclusions as drawn therein with regard to the provisions of section 52 of the Act of 2000. Also, this court having noticed that this court further notices that the order dated 29/5/2026 was not preceded by a notice to the petitioner, wherein the intention to close the IMFL on shop was intimated to the petitioner, as well as the period for which such closure was to be so effective. The present in the order dated 29/5/2026, it is found that the closure now ordered is without any limit of time. Also, the petitioner's rights under 19(1)(g) is also found to have been infringed. Accordingly, till the next returnable date, the impugned order dated 29/5/2026 shall remain suspended. However, considering the fact that power has been conferred upon the district or subdivisional magistrate to close down IMFL, to close down establishment wherein intoxicants are sold by retail with a view to preservation of public peace. This court provides that in the event there continues to be any apprehension, any requirement of taking such step for preservation of public peace.
May I just only one line, my lord. Lordship will kindly have para 8 of the judgment, my lord. This honorable court came to a conclusion that if there is any violation of the provisions of the license, because this code is
52(1) is different.
I'm sorry.
Here, the violation is slightly different.
My lord, what I have understood is that public peace and tranquility cannot be for eternity, my lord.
That's what we say.
Exactly.
We have said, that's why we have stated. So, Kili. And so, the district magistrate or subdivisional magistrate shall take such action strictly in compliance with the provisions of subsection 1 of section 52. That is after issuance of a notice to the petitioner. We can't leave them at large because tomorrow, if there is
I understand.
So today we have protected you, but
only one small prayer, my lord. Only one small prayer.
Your small prayers are very dangerous.
No, my lord. Lord, one small prayer. My lord, respondent number 4 and 6, they may be directed to give some police protection because after the stay order, the consequence is that I can open the shop.
Also,
otherwise,
at this stage, Mr. H.K. Das has submitted that as there is no violation, there is no allegation of the petitioner violating any of the conditions of the license, a direction be issued to the respondent number
4 and 6.
4, 5, and 6.
Yes.
To ensure that no damage is caused to the establishment of the petitioner after it is reopened in terms of the directions passed by this court. The prayer made by the petitioner is reasonable. Senior counsel for the petitioner is reasonable, and accordingly, the respondent number 4, 5, and 6 would provide the requisite protection to the establishment to requisite protection to the petitioner for operating his IMFL on a retail shop, IMFL on establishment, that is Messrs. Rishi Restaurant, in the event so and so by strictly complying with all the provisions of the license as issued to him.
Deeply obliged. Obliged, Lordship. Much obliged.
What is the difference between much obliged and deeply obliged? Something, it depends on the orders passed or.
It's all, much is more, deep is deep, my lord.
Now, how deep is deep and how much is much?
It's, however deep, it comes from the heart, my lord. Much obliged.
Heart on the left side or on the right side?
Less. Highly obliged.
We'll fix a date. You want a date to be fixed? Yes, yes. Racely to list this matter again on 13 or 26?
26.
26. 26 is last day. 2 weeks.
Since Lordship says issued notice, can it be after the vacation, my lord? Picture will be clear, my lord.
Picture otherwise is also clear. 24th. 2 weeks, 24th.
And Lordship, if I pray one thing, a police report may be called for from the Supreme Court. A police report. For
You have called for the police report. You have given him license. Now you take all this.
The excise is not in a position to handle this also.
Madam knows how to handle police things. She will handle.
Obliged, Lord. Deeply.
None appears for the petition on call. Oh, Mr. Sharma, you have filed your additional affidavit?
Yes, yes, my lord. Chief, may kindly see page 79 onwards, 79, 88, 81.
This is which department? Urban. Who is urban? You
Urban
are
water,
being urban.
None appears, my lord. Notice served, my lord. Office note 12/6/25 and 3/6/26.
Seen the office note dated 12/6/2025, wherein the service of notice upon the respondents have been held to be respondent number 2, 3, and 4 has been held to be complete. Also, accordingly, the matter was listed for admissions. The petitioner has filed an additional affidavit as in terms of the undertaking made before this court on 6/5/2026. However, this court for proceeding further in the matter would require the presence of the respondents number 2, 3, and 4. Accordingly, the petitioner is directed to take fresh steps for service of notice upon the respondent number 2, 3, and 4 by way of dusty mode routed through the registry of this court. On effecting service by dusty mode upon the said respondents, petitioner to file an affidavit. Otherwise, we can go nowhere.
Yes, yes. Obliged.
Registered to list this matter again after 2 weeks. You file it immediately.
After filing the affidavit.
List the matter after filing of the affidavit by the petitioner upon effecting service by way of dusty mode upon the respondent number 2, 3, and 4.
Obliged.
May I please your lordship? Lordship, the matter pertains to non-release of my security deposits, your lordship.
My lord, Mr. Dinath will be appearing in this case. He is currently in legs in court number 9. So if the matter may kindly be passed.
Oh, you can also place the instructions. We don't discriminate.
So will be personally appearing in this case, my lord.
Lordship, they have filed their affidavit.
We have filed our affidavit as of yesterday. That was brought on record today.
We only want to know, how can you apply this subsequent notifications, extension of defect liability period retrospectively when the work was order plus 5 years was complete? Okay, get Mr. Nothing. That is the case.
Lordship. May I plead
We
your
have
lordship?
raised an allegation. The allegation has been answered in the inquiry report. The matter pertains to a factual rebuttal, my lord. I had taken time on 13th May, seeking some time. Yet to receive instructions, if your lordship is kind enough to grant us one more date to prefer our reply to the affidavit, my lord.
And lordship, I also filed affidavit in opposition on behalf of respondent number 6. It is not in record, lordship. So lordship,
Mr. Sharma?
my
Nothing in this petition. If they are seeking time, then if in the month of August, Lordship.
So if they seek time, there is something in the repetition.
Because Lordship, it's a very much apparent, Lordship. In the month of August, Lordship.
August?
A further
August.
week's time
What
is
was it?
granted to Mr. M. Sharma to file a rejoinder to the affidavit filed by the Fisheries
The
Department.
Fisheries Department
Fisheries.
and
And also by the respondent number 7. No further adjournment, 2 weeks, period, no further adjournment. shall be.
grateful, my lord.
After vacation.
2 weeks, whenever it comes.
And my lord, there was also another query when notices were issued in the matter, my lord. There was another query which was posed by this honorable court that the Fishery Department has not come back on. That
Oh, if they don't come back, we will answer it.
No, Lordship, may record it. I will produce a record.
Okay.
I'm
Lordship may record them. In that
Mr.
case,
Sharma saying records will come, we will not record. We know Mr. Sharma will bring record.
Lordship.
That much faith. Don't let that faith to go away.
grateful, sir.
Yes, Mr. Dekar. You are also excise. I find all excise misplaced today.
This is
You
not-
want to open or close?
This is not so misplaced.
No, no, you
The other one is absolutely
clearly misplaced.
absolutely misplaced.
Now you have 2 excise people. Earlier there was only 1, now there is 2. Yes.
Here the issue is, my lord, that there is a particular clause in the tender that is creating the problem. Everything has
You are
been
not
done.
filing a reply?
I'm not filing a reply because, my lord, it is in the form of a complaint. My lord. At best, that has to be considered and dealt with by the district collector. My lord. The stand of the municipal board is that there were complaints regarding establishment. My lord. But they are not the authority to decide. If your lordship peruses rule 295 of the excise rules,
That is with the power is with the
power is
excise.
with them, my lord. It is for them to consider. And they have already given me the license, my lord. I have deposited the money.
And when you took this license, this is in urban area.
This is an urban area.
Have you taken the what do you call that? No objection from that municipal board?
That is what is causing problem, my lord.
Where is that condition in the tender?
Page 28.
Clause 3.1.10.
Because actually, my lord, this is not a
Clause.
clause 3.1.10.
So if without this fulfilling this condition, how did they proceed? How did they proceed in the matter?
They have given the license, and I am the highest bidder. Lordship will kindly come.
No,
to
but
my
you have not satisfied the condition of
It
the
is,
contract.
it is ultimately for them, because there is no provision in the rules as such that such an NOC. It is a tender condition, my lord.
They have incorporated this condition.
Ultimately, it's a tender condition, my lord. It is for them to decide whether they'll insist upon this or not. Had it been a statutory requirement,
I found that you have been insisting on this in some cases.
NOC, yes, your lordship. We have been in tender case. What happens is the clause is there, particularly to get the NOC. But as we go by the rule doesn't say about any NOC.
Now, then, if that rule is not there, why have you incorporated here?
That's a,
And if you have incorporated it here, why are you not applying it equally to all? Because in some cases, I have found that because he does not have an NOC, you have not given him. Some district. I forgot exactly what was, but I remember it was a panchayat certificate was not there. So you have not given.
right now, what the rule has changed, your lordship. Now what we do, if we have to open a shop in the premises itself, we put a notice board.
We say that if anyone has objection within that 75-meter.
Have you amended the rules to that effect?
Yes, now we are giving them, everyone giving 15 days time to give an objection. If no objection is coming forthwith, we deemed as there's no objection. Now the issue here is that Rule 295 says objections from local bodies and following person will be considered. It doesn't talk about any NOC. Now
So this affidavit is only by the
Polasbari.
Polasbari. Now, what is your stand on that?
Our stand is clear, Lordship. 3.1.10, the tender clause says that NOC has to be issued. But the rule doesn't say that regarding any NOC.
So
Now,
you say that.
and we have already given a sanction letter.
So you're going to continue with that. But he will have to have a trade license now. Where will you get your trade license?
That the municipal board may create difficulty, but
Yes,
then
they'll
that
have
will
to-
be again another cause of action.
No, we'll resolve it here only. Why take 10 causes? Who is appearing for the municipal board? Yes, madam. Something which all the people love and you are now trying to block it.
She has to place it before the authority because this is the
No,
objection.
maybe if the that was just a tender condition. It's not a requirement of law.
We are not on whether it can be given. If decision will be taken
So
by the authority.
can you make that statement?
Lord,
That
this-
if they continue, you have no objection?
I can't say this, my lord.
That will
Lordship.
be the end of the matter.
Why Lordship will
Mr. Decca will be very happy.
Lordship will put it on this, my lord,
No, I'm
this
not
order.
putting it in
Because
you.
Lordship,
I am putting it in the
Lordship,
chairman.
what happened, my lord, only we have received the objections from the local bodies and my lord, that committees and all. I have already annexed the tender, annexed the complaints. And my lord, we are, my lord, bound to place it before the authority, my lord. Now decision will be taken by the authority, my
Who
lord.
is the authority?
This is district collector, my lord.
So you mean to say that if the district collector tomorrow agrees,
We can't say anything, my lord, on that.
so you will accept?
Only we are only, my lord, Lordship.
This court is not that.
Lordship,
it's
Lordship.
very backward.
Correct, my lord.
So bear with me. I can't
Lordship.
catch up very fast.
Lordship.
So tomorrow, the deputy collector or the excise department says, no, we have given him. That was our tender condition. We are not considering. Then will you withdraw this decision of not giving a NOC?
That will be taken by the board of law.
Oh.
Cannot by only chairman.
How can we have ifs and buts? It should be one go.
My lord, tender
You
con-
tell,
I-
let the excise department do whatever it wants to do. We stand by our finished. We'll take care.
Lordship, that I'll have to take instruction in that case because here only I am to forward the complaints, my lord, because we can't give NOC because we have.
When did you
received the
forward?
complaints.
There is no forwarding as such.
My lord, that is received by the ADC's report is there. Some.
My lord, safety, my lord, go by the rule. Who can lodge complaint? That is also very clear.
Mr. Gogoi, don't come. This court is otherwise confused. Don't confuse again.
Confusing.
I'm confused. I'm confused. Don't confuse again. Mr. Gogoi, have you received any forwarding from the municipal board in terms of this resolution that they have brought on record?
Resolution.
65, there's an inquiry report, Your Lord.
Yes. This ADC's report is there.
No, I'm not on that.
The resolution is not forwarded as such.
They have taken resolution by themselves.
They have taken a resolution by themselves and they have resolved that they will not give the NOC to me.
No, Ms.
That-
Das submits that this is taken and it will be given to the deputy commissioner.
As per the annexures, my lord, there is no such thing, my lord. If they
Yeah.
have done it separately, that I can accept.
To take instruction, my lord, where if it is, because only we have placed the, my lord, complaints. It has been,
How did you make this? Some instructions given to you to this connection?
I'll have to take instruction,
No, you made a submission
my lord.
that you have taken this decision
Yes.
and you will place it before the competent authority, which
My-
is the district
Correct,
commissioner.
correct, my lord.
Who told you that?
That my chairman, my lord,
Okay,
the secretary.
letter. Ms. Udas, learned counsel for the learned additional senior government advocate appearing.
My lord, this is as advocate, my lord.
As advocate, learned counsel appearing for the respond number 5 has submitted that she has been instructed
As per instruction.
that the resolution as adopted by the Polachbari Municipal Board in its meeting held on 12/9/2024 to not issue a no objection certificate (NOC) to the opening of the IMFL shop by the IMFL
Of
off
license.
top by the petitioner would now be placed before the jury, would be placed before the, this is of 24,
24.
be placed before the district collector for further decision. It is submitted that the decision as would be arrived at by the district collector, and for that matter, the excise department would be followed by the Palakbari Municipal Board. She submits that she be granted a week's time to receive further instructions in the matter. 1 week's time?
I'll have to, I couldn't follow whether I'll have to get the forwarding letter or
No,
by which they have.
we have
placed
said that you will forward it
it.
to the director, and then the deputy commissioner, whatever he says, you will follow. Now we say, what have you done?
My lord, I can only place before your lordship the forwarding of the complaints to the, my lord, competent authority.
Only.
my
And also that further that you also get a written instruction
lord.
that the decision that the deputy commissioner would.
Instruction I haven't received. How can I get that, my lord?
No, you
Part and
get
part?
it.
Because our, my lord,
Last thought to cut it. I understood.
only lordship.
Wait.
Lordship.
Last thought kata.
Can't say.
Last line to kata will be placed before the district collector for further
This is
decision. Ms. Yudas on the next date shall receive in writing instructions from the chairman of the Palakbari Municipal Board as to the steps they propose to take once the decision is arrived at in the matter by the district collector, and for that matter, the excise department.
I'm not getting your lordship, sir.
You're not getting me. Read
No,
me or
because my lord, the chairman's only her only she is to do only forward the complaints, my lord. After that, my lord, what they will do, we don't know, my lord, because our role
what
is
they
there, my lord. After forwarding, my lord.
they will do, that is for them to do.
My lord.
My question is, once they do something, what will you do?
My lordship. After, if license is issued, then what will be the role of the chairman?
License is already issued. Once that your complaint they don't accept,
my lord.
then what will you do?
Yes.
Because there are certain further hurdles for it.
Yes, my lord.
We don't want that to remain.
So, my lord. Trade license, yes. Lordship.
Mr. Deka is not here. He is there.
They are in Palasbai. In 2 shops, my lord, this problem has
Mr.
been
Deka
there.
is not here for your no objection. He is there for trade license.
My lord, in this matter, my lord, we have already paid some amount of more than 2 crores. Now, my lord, for this, my lord, year, financial year, we have already for budget allocation, my lord, we have sent proposal, my lord. After the budget allocation, my lord, we can submit the proposal, my lord.
12 crores.
My lord. This is not a single firm, my lord. There are numbers of firms.
How much time do you want?
Lordship, may kindly fix after the vacation, or in the meantime, we are already proceeding.
As agreed to by the Illinois Council for the parties, registry to list this matter again after the, again on 27/2026. On the next date of listing, Mr. S. Dr. Learned Standing Council, Panchayat and Rural Development Department would place before this court the further processing done in the matter towards release of the admitted contractual dues of the petition.
Well, hello.
Regarding settlement of that lordship, both the petitioner and the lordship private respondent offer the same bid value. Not as per provision, lordship, they are required to use the tossing. That was not done.
The tender was cancelled.
My tender in the CS, it appears that cancelled, but in the resolution, lordship, that has been accepted. Lordship, kindly see the resolution page 28. In the CS has also signed 2 page 38. and
38
your
or 20?
Page 29, your lordship may
Ah.
Page 29, serial number 1 to 4, lordship.
You are Ismail Hussain Mundal.
All are rejected, 1 to 4. And I am Ismail Hussain, that is serial number 5. My tender paper was not rejected, allowed. And he is serial number 6. And how, lordship, page 30 is important, lordship, page 30.
Yes, Mr. Dotto.
My lord, I have the.
You have issued a tender. There is a particular list of documents he has to given.
My lord.
Somebody has given you 10 more pages. Will he be the, that would be a criteria.
My lord, fairly I'm
You
submitting.
have lottery done. That is one of the expected.
What, my lord, the committee has accepted, my lord. They have, my lord, said, my lord, actually, my lord, all the bidders are not valid. Properly, 100% documents, none of the bidder has been, my lord, supplied, submitted with the bid. And they have, my lord, what say they,
Then
they
why
are
did
saying.
you say that they are technically qualified?
My
They
lord,
are responsive. Why did you draw the conclusion that they are
my
responsive?
lord, the record is saying, my lord,
We
that
don't want.
private respondent has submitted, my lord, more documents more than the petitioner. That is.
No, what are the documents more than that he has submitted?
My lord.
What are the documents?
My lord.
Where is the tender? Tender documents, which is required?
Lordship, page 17, your lordship may kindly see the documents what we have to lordship submit.
Petitioner number.
Page part 2, lordship, page 17.
Islam Ali.
7 documents. You had a guarantor?
No, and
No.
the lordship.
Your own land value?
Lordship, guarantor was some another person.
No, you had a guarantor with you?
Yes, yes.
So guarantor affidavit
Guarantor has
given?
submitted the Jamabandi, land document.
Jamabandi and the affidavit also?
Yes.
Then a 10% fixed deposit, Assam Cooperative Bank you have given?
Yes.
Passport size photo, PAN card, Aadhaar card, voter ID given?
All these things, lordship, we have.
This is the original.
Shall submit proof of tax-free, the Bakijai clearance?
Everything clear.
Tender shall submit the past antecedent, police report?
Yes, police report is also submitted.
Tenderer having involvement in so and so are allowed to settle?
This is the original CS, my lord.
Hmm.
The first one is
the
private respondent, my lord, and the second page petitioner is there, my lord.
Okay. This is Iman Ali is petitioner.
Private.
Private. So he submitted Gaon Panchayat tax clearance, self-affidavit, Jama bonds, land verification. You had a guarantor? A registration of boat. Fitness
Nowadays-
certificate. The main thing, fitness certificate
Nowadays,
is
my
not
lord, guarantor is not necessary actually, my lord, because 100%
100%.
they have to deposit.
Yes, 100% is required to be deposited.
And what is the name of the petitioner?
Petitioner next page, my lord.
Serial number? Name. What is your name? Your name?
Ismail Hussain, my lord. Ismail Hussain, my lord.
So this CS is signed by 2 persons only, secretary and president.
Yes, what is the difference? Nothing. What are the extra documents he has given?
My lord, I have to check that, my lord. The auction bidder.
Settlement made.
Yes,
settlement
it's
made.
about to end in 30 June, my
It's
lord.
going to expire in this month, lordship, 30th of June.
In the meantime, lordship can have this, my lord. Vernacular.
What is the name of the respondent?
Emmanuel.
Emmanuel. But the private respondent has not submitted the affidavit, which is requirement.
Why? He is not given his land. The land is somebody else and you don't require land. How can you deny him that? You only said land is not required.
Because already 100% they have.
So we are interfering with this. But Mr.
Lottery for the last 2 weeks, man.
One day also.
Yes, man. That is why I have started with my lord that none of the bidders were valid bidders.
Heard Mr. M. Khan, Learned Counsel for the petitioner. Also heard Mr. S. Dr. Learned, Standing Counsel, Rural Development, Panchayat and Rural Development Department, appearing for respondent number 1, 2, 4, 5,
6 and 7.
6 and 7. Also heard Mr. Chetia Learned, Government Advocate, appearing for respondent number 3. And Mr.
M.A.I. Hussain.
M.A.I. Hussain, Learned Counsel, appearing for the respondent number 8. Also, the challenge in the present petition is to the settlements, is to the decision arrived at by the standing committee of
Lordship, Dewaner Alga to Beparipara, Sheloghat, via Suksa.
No. Panchayat to Navar.
who has taken the decision?
Page 40 Lordship.
Page 40. Number 25, number Borai Alga Gaon Panchayat, page 45. Huh? To settle the market, settle the ferry ghat in question. To the ferry, settle the Devan Ner Alag to Bepari Para Shallow ferry ghat via Sukcha for the year 25-26 with effect from 1/9/2025 to 36/2026 under Borair Alga Gaon Panchayat with the respondent number 7. Respondent number
8.
8. And the consequential order issued in this connection on 1/9/2025. The short list which arises for consideration before this court is to the manner in which the selection of the bidder is the procedure is with regard to the validity of the procedure adopted by the respondent authorities for settlement of the ghat in question after both the petitioner as well as the respondent number 8, who were found to be valid bidders, had quoted the same rate, that is rupees
8,690.
8,690 per.
This is for that period, Lordship. 1/9/2025 to 30.
For the period. Oh, you got it very. 8,690. Huh? Also, the materials brought on record reveal that the who had taken that decision that you showed me now?
My lord, the standing committee.
Standing committee of which?
That Gaon Panchayat, my lord.
Gaon Panchayat, no.
Yes.
Gaon Panchayat, Kajjalar, the standing committee
Of Borair Alga Gaon Panchayat.
of Boyar Alga Gaon Panchayat in its meeting held on 27/8/2025, noticing the similar bid value submitted by the petitioner and the respondent number 8, proceeded to select the respondent number 8 by holding that he had submitted more documents than the petitioner herein. This court has perused the said resolution and finds that from the comparative statement brought on record, it is seen that both the petitioner as well as the respondent number 7 had submitted all requisite documents. Respondent number 8 had submitted all requisite documents as mandated in the tender, and accordingly, a distinction between the accordingly the set standing committee could not have adopted a criteria for settlement of the Parghat it's na? Parghat in question by only considering the number of documents attached to a tender. So this court finds that the said procedure is adopted to be not in conformity with the normal process required to be adopted for settlement of state largesse. So accordingly, the said procedure as adopted by the said standing committee stands interferes with the interference with the decision of the interference with the procedure adopted by the standing committee for selection of the successful bidder in pursuance for settlement of the Parghat in question would consequentially mean that the selection of the respondent number 8 is also interfered with. Also, accordingly, the selection and the consequential order dated A19-2025 settling the Parghat in question in favor of the respondent number 8 stand set aside. Having set aside the said settlement effected in respect of the petitioner, this court directs the respondent authorities to settle the Parghat in question by treating both the petitioner and the respondent number 8 to be eligible bidders, and by following a draw of lots, which would be so conducted with the presence of the petitioner and the respondent number 8 and or their representative. The said draw of lots be completed be held on or before 11/6/2026. Thereafter, the settlement be made in respect of the selected bidder within a period of 3 days, that is by 15/6/2026.
Petitioner will serve a certified copy, my lord.
Mr. Dutta shall today communicate the order passed by this court to the respondents. Also, further, the petitioner shall also obtain a certified copy of this order and place the same before the secretary of the concerned Gaon Panchayat for compliance of the directions passed herein above.
My lord, instead of today, my lord, after tomorrow, because I have to annex the copy also, man. Online copy.
Oh, you can tell phone that this is the order passed.
Man.
Night you can send them, I'll have it uploaded. Night you can send them a WhatsApp message.
Man. Highly obliged.
Yes, Mr.
Yes, my lord, we can pay 10 lakhs, my lord, within a month, my lord.
Within a month will not do, 15 days. Mr. A. Sharma, A.K. Sharma, Learned Counsel for the petitioner has in terms of the undertaking given by him on 3/6/2026 completed his instruction and has submitted that the petitioner would be depositing an amount of rupees 10 lakhs within 15 days from today. Subject to the said deposit being made within a period of 15 days from today, the interim directions passed earlier shall continue till the next date of listing. In the event the amount is 10 rupees, amount of rupees 10 lakhs is not deposited with the respondents before completion on or before 15 days from today, on the with effect from the 16th day from today, the interim orders would stand vacated and the respondent shall be at liberty to proceed in the matter for eviction of the petitioner in accordance with law.
Lordship,
So you get 10 lakhs more.
Lordship, only one line can be added because we know that again they will come for extension. There were no further extension will be given. If Lordship add only one line, 3 times earlier.
The only problem, Mr. Chomoria, is I may have many qualities, but I don't have the qualities to know what is going to happen the next
My lord, last
so how can I know what is going to happen?
My lord, last expense 3 time extension.
I can only know one thing. I'm rejecting your display.
Deeply obliged.
If I get that power somehow, I'll let you know.
My lord.
Yes, sir.
I am for the picture, my lord. My lord.
Yes.
I am covered by few judgments, my lord. On 4th of May, my lord, I have submitted written argument along with few judgments. I have given copy to my learned friends, my lord. And one additional affidavit I have given to my learned friend, my lord. So a joint is appearing on behalf of the one of customs authorities, my lord.
Yes. What do you want today?
My lord, my release of the goods, my lord, release of the Erica nuts, my lord. Well, despite my lord, direction, my lord, they did not choose to file affidavit, my lord. Well, kindly matter is urgent.
When was the season made?
My lord, these are made on, my lord, 2nd of December.
30/11/25.
My lord.
In Bodorpur. You are Mr. A. Hamid.
Mr. A. Hamid.
Yes.
Lordship, may please to see the order sheet. On last occasion, we were directed to obtain instruction. We were never asked by the Honorable Court to file an affidavit. Lordship, their application for provisional review was rejected. Against that, they have come before this.
Only assumptions, the reasonable belief that it is a foreign origin. It is not. Well,
Yes,
all
what is the basis of that reason to believe, Mr.
Lordship, please to see the order is annexed at page 43.
Mr. Hamid, normally you practice here or
Well, Kolkata.
Kolkata? I've not seen you, that's why I was.
My enrollment is in the year 1983.
I may have been in class 4 or 5, 6 maybe. 6 years.
I'm running 69, my lord.
How do you look healthy? Remain like that.
The reasoning is
the judgment.
Page 51.
Mr.
paragraph
Hamid,
3.
please have your seat.
Well,
Yes, Mr.
What's the page 51? This is a part of that rejection order. G. Married Lords. As stated above, it is apparent that the attempt to smuggle the goods into India has been done.
No, where is that? The reasonable belief that this thing has come from Burma.
Lordship, initially under section 113, their goods were seized on belief that this was a smuggled goods. Therefore, they filed an application for provisional release. That was rejected by this order. Lordship, this application was taken into consideration.
I got it. But where is the belief, reason to believe? Because you have to form a prima facie opinion.
Not sir.
Basing on some material that this material seems to be from.
Lordship, then may allow
it
to
is
produce
covered by licit documents. Licit documents were submitted to them. They verify all the licit documents.
Then I may be allowed to produce the records, Lordship.
No. Records will come, but how do you justify that the reason to believe? Reason to believe cannot be a apprehension. It has to be more than that. So where is that material, Mr.
Let's see page 45.
Huh?
Page 45.
45. No, this is just a allegation.
Let's see.
Where is the basis? Have you checked that ARANET with you, ARCANET?
Records.
Then you might have found, oh, this is not,
let's see.
this is not from Assam land. This is from Burma.
May I please to see page 45, paragraph I.
Huh?
Samples were drawn from the
Huh.
seized goods from the bags as mentioned in the schedule for the inventory above. Two representative samples each weight 500 grams were carefully drawn.
No, this is only for the purpose of human consumption.
My lord.
And
let's me please to see. These samples were taken to ensure the accuracy apparent, ensuring quality of the seized materials. The purpose of drawing samples, sealing these samples is to facilitate the subsequent laboratory examination and testing in order to determine the nature and origin of the goods and to assess whether they were fit to human consumption in accordance with the applicable quantity and safety standard. Then Lordship, next paragraph. The application for provisional release and the case record has been examined carefully in details and the following has been found. First, the laboratory examination report submitted by the State Public Health Laboratory Bhavnavedan has been examined. It is found that the laboratory is found to be accredited by the National.
So this is again, Mr. Just to cut short the time. This is again confirming to the prescribed standards. This is fit for human consumption.
Page 47.
47, yes.
Opinion. The samples confirmed to prescribe standard as per food safety and standard regulation with respect to the test carried out. From the above, it is found that the goods are meant for human consumption and the tests are carried out as per the food safety standard. Manual method of prescribed standard, however, on examining the package 1, find that the no FSSI license number is printed on the package as required under FCA so and so. Further, the package does not contain the mandatory requirement of required under legal methodology read with the standard so and so. Then Lordship,
when
the goods are presumed to be Indian origin, the goods then also be packages has to follow the mandatory requirement as required under legal methodology so and so so and so.
Can it be confirmed, my lord, that it is a foreign origin, my lord?
You have a GST registration.
My lord, everything.
And whether
they did not dispute the documents, my lord.
No, whether that betel nut is one of the businesses you have,
Yes, my lord. Yes, my lord. Yes, my lord. Documents is here with the writ petition as well as its arguments, everything, my lord.
What are the decisions you want to rely upon?
My lord, kindly see my written notes of argument, my lord. The decision, my lord.
The written notes of argument are not on record. Hey, who doesn't even? Have you submitted a copy?
Yes, my lord. Yes, I have submitted, my lord. My lord, page 12, first judgment, my lord.
Coach copy is not there.
হ্যাঁ আমি দিয়েছি সবকে দিয়েছি
নেই তো
সবকে দিয়েছি আপনাকেও দিয়েছি
আমি তো পেয়েছি আমার হাতে আছে
Is it the additional affidavit you are relying on?
No, my lord. On 4th, my lord, I have submitted, my lord. Before Justice Bodua, my lord. 4th of May, my lord.
Not here. When can you come back again?
My lord, any Monday, my lord.
You produce the reports. We are putting it on Monday.
Well, not Monday. Then Friday, my lord. Friday.
That will be better.
On the prayer of the learned counsel for the parties, registry to list this matter again on 12/6/2026. Mr. R. Hussain. Ms. Har Hussain, assisting Mr. S.C. Kel, has submitted that the records in original would be placed before this court on the next date of listing. Registry to list this matter on 12/6/2026.
But at the top, my lord, I'm coming from.
You can make a mention, no problem. Make a mention.
Well, I beg you, lordship order, well, make it part heard, my lord. First, the matter was heard by Justice Bodua.
He's
Second,
coming, Mr. Bodua,
I'll beg you.
don't worry about it.
With the consent of my landed friend, my lord, I beg you. My lord, I beg you.
I
But
don't know.
I'm senior counsel,
Mr. Hamid.
my lord, I am
Mr.
begging.
Hamid,
My lord, only one thing, my
Hamid,
lord.
the problem is,
Only-
I don't know what my rooster would be next week.
My lord, kindly make it part out. I am beseeching you, lordship, my lord. Kindly.
If it comes back to me,
My
I'll hear
lord,
it.
kindly.
Oh, Mr.
Kindly.
Hamid, please don't press. You're a senior man. I can't say no, but
Well,
that will be not what I do normally. Please, I've not heard it. Just took a smell of the thing only. And next time you are in my court, you are coming from outside, please free to make a mention in the early hours, you or your
Well,
junior.
first Justice Bodu, hard then Justice Soyama, you are third, man. You are so lucky.
No, this is, we are all one. We are all one in different avatars. That's all. Come here, feel free to make a mention. If matter is before me,
My lord, may I submit the, kindly record, may I submit the
No.
argument, my lord?
you just feel free to make a mention at 10:30. I will take a matter as early as possible.
My
That much I can assure you.
My opinion.
Original record is here, Lordship.
See the inquiry report
Lordship.
or the statement of the
Accused.
accused. He's admitted everything.
Admitted, Lordship. Clear admission.
But Mr. R. Chetri, Learned Counsel for the petition. Okay, very important. Any urgent matters? Any urgent matters? Because this may take some time. Because I have got to pass 2 more orders. Yes. Please feel free to come and tell me. Because I have 3 orders to pass, may take some time. That's why I said
58, 59, I think.
58, 59. Yes, what do you want?
Then item 48 may lordship may close it.
We'll just close 58, 59.
58 and 58.
Yes, 58, 59, what do you want?
My lord, matter may be disposed of in terms of the order dated 2/9/2025 passed by the Chief Executive Officer, Kamrup Jilla Police, who here in respondent number 3.
58, 59.
So we have filed
Next
a
matter.
affidavit, my lord. We have filed affidavit in both the matters, my lord,
Now, do you agree to that?
saying that they are defaulters, my lord. The petitioner may respond there.
No petition.
Which is the order you want to comply?
2/9.
Huh?
2/9.
Where do I get it?
Oh, yes, my lord. Page number, my lord. 39 and 40. Initial 5/6. Initial 5, page number 39.
This is representation, my lord.
No. Settlement order for Kendugana daily market tender. Eventually.
It will be 30.
39 page.
On the prayer of the Learned Counsel for the parties, registry to list this matter again on put out right here, 17/6/2026. We'll see on the next.
Highly.
58, 59. Yes.
My lord. Item number 42.
Hmm.
I pray it may be fixed for hearing. It is in order first item.
All are present.
I do not know, because till they have 42.
Under 42, this file was misplaced, 16 matter matters. We have now got the file. we speak
Register
September.
to list this matter again on (16) 6/2026. So as the parties have, all the parties are here.
I am 40.
You are 40 petitioners.
Yes,
File
I
to
am
the APDC. Till now, my lords, we have not responded. We got a communication that
No, we don't want to touch also. If we touch you, we may also get a shock. So we.
No, my lord, the records of another proceeding, it could be traced back of 1972.
All the respondents being represented by Mr. D. Gogoi, Learned Standing Counsel, so and so, registry to list this matter for admissions on 16/6/2026.
Item 48, madam, it's a contempt matter, madam. We have filed an affidavit. It is, in my understanding, well, it is complied with, madam. Lordship may close this contempt matter.
What does the petitioner say?
My lord, if Lordship comes to my affidavit, Miller.
No, your affidavit will not do. Where is the petitioner? Get the petitioner, we'll close it. You get hold of Mr. T.H. Hajorika or Mr. A. Roshid, whoever it is.
My lord. Or otherwise, if they are not present, my lord, I'll also get free, my lord. If
Tomorrow? Or the day after? Oh, sorry. Monday? Tuesday?
yes,
Wednesday?
any day.
On the prayer of Mr. A. Chamua, Learned Counsel, Dr. A. Chamua, Learned Counsel for the respondent, registry to list this matter again on 10/6/2026.
Lordship, the timing matter, your lordship 34, Mr. Nat was supposed to.
Mr. Nat has come. Yes, Mr. Nat.
Lordship, I am here, Malad. Lordship.
Yes, what are you doing?
Malad, we have filed an affidavit in the matter. Lordship has directed us to bring the notices, Malad, issued to the petitioner in the matter. In fact, Malad, the case of the petitioner is that the defect liability period has got expired. Now the performance security has to be returned. We have in our affidavit in opposition, if Lordship kindly takes up the affidavit in opposition, paragraph number 6, at page 47. Kindly take our affidavit in opposition, page 47.
Before that,
Malad.
Let us understand one thing.
Lord.
The date of completion of the work was?
It was, completion is in 2000.
2311, your lordship.
23/11/2018.
Lordship.
19.
19, your lordship.
So in
23
terms of the contract, what was the defect liability period?
5 years.
So it came into conclusion on 22/11/2024.
2024, 2311, 2024.
22/11/2024.
Lordship.
Your policy
Well,
for extension, automatic extension of defect liability and all those things
Lordship.
was introduced in 2025.
But the portal of the ministry, these works are being monitored by the ministry, and Malad, in paragraph 6 of our
I understand everything.
47.
Tell me, when you don't have a contract subsisting after 22/11/24, how can you bring in something foreign to that?
But in fact, notices were issued in 2023. Those are on record. Kindly see, Malad.
No, thereafter there are certificates given by your officers. 25, come to page 37.
37.
Malad, that I have seen, Malad. That I have seen.
So
Malad,
if this is there, this is in tune with the earlier contract.
in fact, Malad, this notice, this completion certificate, Lordship is indicating page 37 was issued on 24/4/2025. But kindly see, Malad, for a moment, take up my affidavit file today. These are notices issued in the month of in August 2023, September 2023.
Hey, Mr.
Lordship.
Once these are not in terms of your new policy. This was in terms of the defect liability period, because the defect liability period was there till 24. So 23 notices are very welcome. But after that, we have materials on record which shows that it is satisfactorily concluded.
No.
Page
Those,
37.
those work were not done. Lordship,
And then what steps have you taken against
yes.
the executive officer, PWD, Hajus Walkusi Territorial Division? He
Yes,
says, nor any difficulty have been noticed at this end or at the end of the defect liability period of work. So as on 23.
No, how how that certificate came in, that is a issue. Kindly,
Your officer,
true,
have you taken steps against him?
Only on the basis of the records I am submitting, kindly take up my affidavit file today. It is on record,
It's there, I've seen it.
Yes, Lordship. And 3 notices we have given, and kindly see page 81. Page 81. In fact, the executive engineer, he has written to the chief engineer regarding termination of the maintenance package, because despite the letters, he did not rectify the work. And the works are being monitored by the GPS locations. The condition of the road, potholes, those are all monitored by the ministry.
I am totally with you.
Lordship.
Totally with you. But this is a letter written during the continuance of the defect liability period.
Malat.
Plus 5. 19 plus 5. Now, on conclusion of that, we have page 37 onwards, categorical contentions that at the end of the liability period, there is no defect. So this, we'll presume that this 23 thing, whatever it is there, the petitioner has rectified.
No, what I am submitting, my lord, kindly see in view of page 81. Because the petitioner did not rectify the work, he has recommended for termination of the maintenance package at page 81.
I know that the same very authority thereafter on 24/4/2025 has said that the difficult, as per the specification, no any defect liability has been noticed at the end of the defect liability period of the. This is 25, page 37.
I have that, in fact, in view of the notices and the report or the recommendation for termination, this certificate, no defect liability certificate, should not have been issued.
That is should not, that is should not, should be, that is for you to say.
No, the issue is,
it is already issued.
It is regarding return of the performance bank guarantee, because the defect liability, during the defect liability period, those are not rectified.
Okay.
And
when did you, Mr. Show me, have you disowned the certificates? In your affidavit, you have not said anything about this.
On the basis of this was in routine manner they have given this. Otherwise those are records.
You don't understand. You terminate them. Then come back.
And the package maintained by the ministry, the data maintained by the ministry, the GPS location wise, that doesn't show, ultimately.
Where is the SPQs? What do you call that? SPQ. That inspections done by experts. Where is that reports?
Now, in paragraph 6, we have said, paragraph 6 of the page 47. In the chief engineer's affidavit at page 47,
Mr. Nath. This tender is of 2019.
Lordship.
This monitoring thing was not there at that point of time. These conditions were not there. This came subsequently.
No, in fact, condition.
Madam, it came in 20.
Lordship, 25.
25.
34/2025.
34/2025. So if you have to make it retrospectively operative to a contract which by time elapsed on 23/11/2024.
Well, in fact, the ministry's eMark portal, no liability has to come in that portal. That has to be uploaded there. Ultimately, they are monitoring the thing, and because of the notices there.
When was that scheme brought into being? 25.
No, it was in fact, Lordship on last occasion has directed us that as when you have given the notice, because the requirement is that during continuance of the defect liability period, the notice should come. So that
What I wanted to know is
Mala.
whether the notice in terms of the new provisions that have come in has been given to the petitioner. You have not given. 23 notices is covered by the page 37, which says maybe he has done it. Last day there was nothing. So after that, if they wrote something happens, what is the liability of the petitioner?
In fact, the situation is, well, the maintenance work was not done despite 3 notices. And how the page.
Mr. Not in your affidavit, you have not discarded, disowned page 37, 38, 39, 40, 41.
But what action they have taken against this? Because ultimately the chief engineer has filed the affidavit, the first affidavit, because the portal has to ultimately verify.
Mr. The only thing is that portal business came in, not in 19. It came in 25.
No, not in 25.
Madam was saying that it came in 25.
Lordship, 3420, in their affidavit in opposition, they have stated.
Yes, where is that?
Lordship.
Page 55.
Lordship.
And you come to Mr. Please come to page 55, first paragraph.
Mala.
Please read that.
Well, as you are aware that provisions of PMGSY standard bidding document clause 32.1 states that engineer shall give notice to the contractor of any defect before the end of the defect liability period, which begins from the completion date and ends after 5 years. The defect liability period shall be extended as long as defect remains to be corrected. Well, this is not introduction of a new provision. It is already there.
Show me
Malad.
the provision in the tender or the contract agreement entered into with the petitioner of a similar provision being incorporated there. Beyond 5 years.
Lordship. It is by nature of the particular scheme, Malad. It is extendable under clause, Malad.
Mr. You're not getting what this court is finding it difficult.
Malad.
23, you say there was a defect. 24, 25, the documents that have come on record, that defect is not there. Executive engineer is the authority who has to look into it. He says no defect. Then, where is the notice after that? That see, these are the defects we find still continuing, issued to the petitioner after 23. There is no notice.
Malad, I have sought for the instructions pursuant to your lordship's order, but these are the notices available with us.
So, how can it be? So, we'll say that you release now, but there is no other way out.
But ultimately, it is a question of releasing the performance bank guarantee, and we are keeping the performance bank guarantee for 2 years. The question, which lordships have, from lordships, the honorable court has fallen, Malad. Ultimately, it is the adjustment remains. The question of adjustment of the performance bank guarantee with the maintenance work, because if the petitioner doesn't do the work, maintenance work, we have to do it from our side.
He's not mandated to do it because his period came to a close in 24. You allowed him to go.
No, what I am submitting, Malad.
That's why given. Where is the completion certificate?
Page 37, they have annexed in the petition. No, what I am submitting, Malad, if the maintenance work pursuant to the notices in 2023, petitioner has not done. And ultimately the authority, by engaging someone, has to do.
That's for drawing that satisfaction, Mr. Nutt. We don't have material. And the only material is page 37, which proves contrary to what you are trying to say.
In fact, termination was recommended. And what action they have taken?
Why did you not do it? Your affidavit does not speak of anything.
Well, the affidavit of the chief engineer, it indicates that until and unless it is shown completed in the portal, release is not possible under this particular scheme. That we have stated.
That we will take it up.
That we have stated.
We will take it up.
And the release of the performance security depends after adjustment of the thing, Lord, because if he doesn't do, we have to do it from our side by engaging someone else, and the cost has to be reimbursed. That is what the purpose of the performance bank guarantee, Lord, the security, Lord. So release as per this under this scheme, therefore comes after expiry of the extended period of 2 years. And what has happened? I do admit, Lord, that there is a gap. There is a gap, Lord. I do admit. After after 2023 notice, what has happened? That information that has to be taken.
What is this page 53 you have brought on record?
Lordship,
Okay, Mr. Nath,
Mala.
we'll fix it on another date.
Lordship.
When you can also be present online before this.
Mala, Lordship.
You also take instruction as to how this was proceeded between 23 and 24 while issuing those certificates.
Lordship.
Mr.
Lordship, kindly keep it on Tuesday or Thursday, Mala, next Mala. Lordship.
Heard Ms. Deep Masahari, Learned Counsel for the petitioner, also heard Mr. D. Nath, Learned Standing Counsel, PWD. Also, Mr. D. Nath has brought on record an affidavit on behalf of the on behalf of the respondents represented by him in pursuance to the directions passed by this court. Earlier. So, as agreed to by the Learned Counsel for the parties, registry to list this matter again on, let it have it on 10th, 11th, 12th, or 12th will be again this one, 10th. Oh, sorry, 10-6.
10-6, Lordship. Highly obliged, Lord. Obliged.
When is the item? 34.
Lordship, for further hearing, your Lordship. Obliged, your Lordship.
Not heard, I've just
Lordship.
inquired only.
Lordship.
Hey, please, your Lordship. Lordship, item number 47.
Hmm.
In this matter, affidavit in opposition has not been filed yet.
Yes.
Lordship, here the matter is that there's a dispute between two individuals, Your Lordship. License was issued in a partnership firm. One licensee dies, the partnership firm automatically converts the proprietorship, Your Lordship. Now the person is holding the license. The excise department tried to settle this matter amicably with both of them. So none of them agreed any matter in any way, Lordship.
Cancel it.
Very well, Lordship.
Cancel the license, that's enough.
Renewal has been done. Now the person who was partner in the earlier license, he's holding license until and unless he wants the petition wants an inclusion in name in the license. That person has to give us a partnership form, Your Lordship. We have to ask an order for that.
Already, Lordship, we are following rule 301 of the Excise Act. When my father expired.
The license is in the name of your father and was in the name of your father and
respondent numbers, private respondent number 7.
7. Who is he?
He is
relative?
No, he is a friend.
Okay.
He was a friend.
So these two were there. Once one of the partners passed
Expired,
away,
yes.
then it becomes a proprietary.
Yes.
The condition which has been enumerated in the partnership deed, it was like 50-50.
Go before the civil court, get it cleared. Why are you here?
Yes, exactly. And the issue is that the moment he gets transferred to proprietorship, he has to come.
You will have to demand. If he does not give you, you will have to go for cancellation of that.
But the responsibility of the
who is appearing for the private respondent?
Private respondent for on service of notice, it was remain answered. May I pray for taking fresh steps as well as justice service?
Your name?
I am Udip.
Your name.
My name is S. Z. Datta.
Just a moment. Was there earlier any litigation by this person?
No, Lord.
no.
As per my knowledge, no.
He has a, where is the shop situated?
It is situated at Guwahati, Hatigarh Chariali.
Young boy, father died. He has a sister, no mother.
No, mother is there. Mother is alive.
Mother is there.
Yes.
Then it is different.
It's different.
That is a different. Similar facts.
Yes. And that was relative, your Lord.
Huh?
If
That is uncle.
Uncle.
Uncle. ठीक है sir. Seen the office note dated 25/5/2026. Seen the order of the Laujima Court dated 25/5/2026. So, the Laujima Court had required the petitioner to obtain the correct address of the respondent number 7. So, accordingly, the address being obtained, the learned counsel for the petitioner had requested for to take fresh steps for service of notice upon the respondent number 7 by way of both dusty mode and speed post mode. Accordingly, the matter was placed before this court today. The learned counsel for the petitioner has reiterated his prayer for permission to take fresh steps for service of notice upon the upon the respondent number 7 at his correct address. Prayer accepted. Petitioner is directed to take fresh steps for service of notice upon respondent number 7 by way of by way of speed post as well as by way of dusty mode routed through the registry of this court. The service of notice if so affected by way of dusty mode, petitioner to file an affidavit to the said effect. Also, registry to list this matter again after 4 weeks from today.
Obliged, Lord.
Obliged.
Yes.
My lord, supplementary item number 55, Lordship. Apply for Lordship fixing in next to Lordship.
Mr. B. Malaka, learned counsel for the petition, submits that the matter be taken up on when?
Next to any date, Lordship.
On 19/6/2026.
Obliged, Lordship.
Yes, Mr.
Lordship, item number 28, it was called in the first half. I had communication with Mr. Munir for his inconvenience on his part. He has not been today to the court, Lordship.
I submitted that the learned standing counsel, handloom and text, learned item number
28.
handloom and textile.
No, actually, I am respondent number 1, but Munir is respondent number 2 and 3. His name has
not reflecting.
not reflected in
Counsel
the name.
appearing for the respondent number 2 and 3 on account of certain personal inconvenience is not present in the court today. It is stated in the bar. So accordingly, Mr. N. Pathak, learned counsel for the petitioner, submits that the matter be taken up on pension. Areas of
Some area dues on it.
on 18/6. By reflecting the name of by reflecting the name of standing counsel,
Khadi and Gramudyog.
Huh?
Khadi and Gramudyog.
Khadi and Gramudyog. Assam, not Assam.
Assam Khadi and Village
Assam Khadi and
Village Industries Board.
Assam Khadi and Village Industries
Board.
Board. Yes.
Item number 63, Lordship, supplementary discussion. Correction of order, Lordship, one word in the order, Lordship.
Yeah.
This is the wife, second wife of the late. Page number 9, second paragraph, Lordship. It should have been typed as second wife, Lordship. Petitioner is the second wife of. It was typed as first wife.
But Mr.
K. Kashyap, Lordship.
K. Kashyap, learned counsel for the applicant. The present application has been instituted praying for correction of a error, typographical error, occasioning in the first line of the second paragraph of the order dated 27/4/2026 passed by this court in WPC number 3726/2024. Also, in the order dated 27/4/2026, the petitioner has been described as the first wife of the deceased government employee. However, she is the second wife. Accordingly, the following paragraph occasioning, accordingly, the second paragraph of the order dated 27/4/2026 was accordingly, the following was recorded in the second paragraph of the order dated 27/4/2026. Clear? Khalif Tawjad, the said paragraph is now the paragraph on correction now on being corrected would be read as follows. Ali, in the present petition, the petitioner who is the first wife believes a second wife. Page 9 order. Second query. With the present order be read along with the order dated 27/4/2026 for all intent and purpose. With the above observations and directions, the present interlocutory application stands dispensed.
My name may be recorded, Lordship. I am for the respondents.
Heard, Mr. and Mr.
K. Kolita on behalf of K.K. Parasar.
K.
Kolita.
Also heard Mr. K. Kolita appearing on behalf of Mr. K.K. Parasar, learned CGC. Yeah. Yes, Mr. Patwari, what are you waiting for?
Item 44, I am the respondent. Nothing important, but non-payment of contractor due. The finance and the higher education department is to.
And we'll have it after vacations. As prayed for 44, registry to list those matters again after the ensuing summer vacations. But Mr. R. Chetri, learned counsel for the petitioner. Also heard Ms. M. Bhattchaji, learned counsel, learned additional senior government advocate appearing for the state respondents. As agreed to by the learned counsel for the parties, the present petition was taken up for final consideration and is being disposed of by this order. Also, the petitioner herein was in pursuance to his arrest in connection with a criminal proceeding instituted against him, comma. You were placed under suspension first? When? Came to be placed under suspension. Madam, just find out those dates.
Lordship, after his arrest, Lordship, because on last, when he handed over the gun, Lordship, then when he went back to Kokrajhar, then only, yes, Lordship.
No, when is the date of, just give me those dates. There was no suspension, I suppose. When were you suspended, Mr. Chetri?
No suspension order found here.
He was arrested and forwarded on judicial custody on 16/2012, Lordship.
But you have not.
FIR was registered, Lordship, then DP was drawn.
Also, after the arrest in connection with the petitioner, after the arrest of the petitioner in connection with a departmental with a criminal proceeding instituted against him, the departmental authorities, proceeded to issue a show cause notice dated 18/2/2013, instituting a departmental proceeding against the petitioner herein. Also, the petitioner submitted. You have submitted your reply. His reply is there.
Lordship, 1 minute. This was scattered. Reply to show cause notice dated, yes, 18/12, on 5/13, Lordship.
Submitted his reply to the said show cause notice
5/13. 5/3/2013.
5/3/2013. The reply submitted, the contentions raised by the petitioner in his reply not being found to be satisfactory, the disciplinary authority of the petitioner directed for holding of a departmental inquiry in the matter against the petitioner. So accordingly, the petitioner appeared before the inquiry officer and the inquiry proceeded. So on conclusion of the inquiry, the inquiry officer submitted his report and therein held the charges leveled against the petitioner to have been established. Also, the petitioner thereafter was forwarded with a copy of the inquiry report, and he had submitted a representation thereafter. So, the disciplinary authority of the petitioner, on consideration of the materials coming on record in the inquiry, as well as on perusal of the inquiry report and the affidavit and the representation preferred by the petitioner thereon, proceeded wide order dated 15/12/2026 to concur with the findings of the inquiry officer and thereby hold the allegations leveled against the petitioner in the show cause notice dated so and so to 18/2/2013 to have been established, and accordingly proceeded to impose the penalty of removal from service upon the petitioner. Also, no appeal.
No appeal.
Also, the petitioner, after passing of the said order dated 15/12/2016, is not found to have assailed the same either by way of filing an appeal before the appellate authority and/or by approaching this court. Also, the criminal proceedings instituted against the petitioner was thereafter proceeded with, and on filing of a charge sheet in the matter, the petitioner having not admitted to the said charges, a trial ensued. On conclusion of the trial, the learned trial court wide judgment and order dated 18/7/2023 passed in, what is this case number? Sessions case number 150/2017, bracketed new, SC case number 36/2016 old, proceeded to hold that the charges framed against the petitioner to have not been established, and accordingly acquitted the petitioner herein and other co-accused. Also, on his acquittal in the criminal proceedings instituted against him, the petitioner on 11/10/2023 approached the Director General of Police, Assam, with a representation praying for reconsideration of the with a prayer for reinstatement in his prayer for reinstating him in his service, basing on the conclusions drawn by the criminal court in the matter. The said representation not being considered, the petitioner had instituted the present proceedings. Mr. Chetri, learned counsel for the petitioner, has submitted that the challenge in the that this court that the petitioner assigns the order dated 15/12/2016 passed by the disciplinary authority on the basis of the judgment and order dated 18/7/2023, wherein the trial court, basing on similar allegations, had proceeded to acute the petitioner hearing. Also, accordingly, he submits that the trial court, that the criminal court having not, in the criminal proceeding, petitioner not having been found to be blameworthy, the order of penalty as imposed upon the petitioner basing on similar allegations, would mandate an interference from this case. Per contra, Ms. Ms. M. Judge, learned counsel, learned additional senior government advocate appearing for the state respondents, has submitted that the intent of a criminal proceeding and a departmental proceeding are both different. Also, he submits that in the departmental inquiry held in the matter, the petitioner was given all due opportunities to defend the charge framed against him. Also, the petitioner was also permitted to cross-examine the witnesses coming on record. On conclusion of the deposition of the departmental witnesses, the statement of the petitioner was so recorded. By referring to the statement of the petitioner herein as adduced by him during the inquiry, from the records produced in the matter, from the original records of the inquiry as produced by her, Ms. Bachaji has submitted that the same would go to reveal that the petitioner has admitted to the charges, to the allegations of charges as framed against him in the departmental, in the show cause notice dated 12/18/2013. Accordingly, he submits that the said position having come on record during the inquiry, the conclusions drawn by the inquiry officer in the inquiry report would not mandate any interference. Also, she further submits that the disciplinary authority on a due examination of the materials coming on record in the inquiry, having concurred with the findings so recorded therein by the inquiry officer, and it being clear that such conclusions were made on legally admissible evidences coming on record in the inquiry, including the admission of the petitioner herein, the impugned order dated so and so. (15/12/2016) would not mandate an interference from this court. Also, I have heard the learned counsel for the parties. Accordingly, she submits that the impugned order dated so and so would not mandate to issue a report. Also, I have heard the learned counsel for the parties and also peruse the materials available on record. So, eta paragraph khali tan. This court has perused the conclusions drawn by the learned trial court in the criminal proceedings instituted against the petitioner. And this court finds that the learned trial court, basing on the learned trial court noticing that the two independent witnesses had not supported the prosecution version of leading to discovery of the seizure of two SLRs, SLR Porus, the charge of the accused persons, including the petitioner, being in conscious possession of the firearms was not proved. It was further held by the trial court that no direct or circumstantial evidence of the influence of the with regard to the involvement of the accused therein, including the petitioner, in an armed conflict or planning and organizing such conflict was brought on record by the prosecutor. Also, accordingly, it was held that there was also no credible evidence to lead a conclusion that the accused were members of a terrorist organization. Also, it was further held that the prosecution had not led any evidence whatsoever to show that the AULA was a banned organization or at or about the time when the accused was apprehended. Accordingly, it is on the basis of the said conclusion that the learned trial court had proceeded to acquit the petitioner and the other co-accused. However, from the materials coming on record, however, from the statement of the petitioner, this court finds that he had in categorical terms accepted the charge, the allegation so leveled against him in the show cause notice dated 18/2/2013. Also, he had admitted to being involved in transfer of arms on behalf of a proscribed organization. Also, the petitioner had brought on record during his statement that a statement of more than one incident wherein he had favored or helped out the members of the proscribed organization in transfer of arms and ammunition. So the said material coming on record in the inquiry has not been disputed by the petitioner in the present writ petition. Accordingly, considering the manner in which the prosecution had conducted the criminal proceedings against the petitioner, this court is of the considered view that the decision of the learned trial court being not so arrived at after all the requisite evidences material to the issue were placed before the trial court. So this court also holds that the trial was not a hot and contested one, and accordingly, the acquittal of the petitioner therein subsequent to his dismissal from services would have no effect in the penalty of dismissal from service imposed upon the petitioner. First paragraph to the charge framed against the petitioner in the show cause notice being relevant is extracted here in below. A2. Okay. Page 51, A2A. The perusal of the said charge would reveal that the allegations leveled against the petitioner, the show cause notice would reveal that the allegations leveled against the petitioner are serious in nature. And it was alleged that the petitioner was involved in transportation of arms and ammunition under directions of the chairman of a proscribed organization. It was further alleged that during the year 2010 to 2011, he had received illegal arms and ammunition on behalf of extremists. Also, the
Shall I leave the original record?
the records in original as produced by Ms. So-and-so, Ms. M. Bhattacharjee, Learned Counsel for the petitioner, is returned in the court itself,
Oh, okay.
in the court today. Sorry, Mr. Chetri.
All right.
Deeply obliged.
Two minutes. এখানে DDS, What about DDS? Yes, which one?
My lord, item number 25.
Hmm?
25, my lord.
Anything to say? Where is Mr. Soikia? You want to argue or you want Mr. Soikia to argue?
Mr. Soikia.
On the prayer of Mr. Ayala, Learned Counsel for the petition, registry to list this matter again on on 12/6/2026 for further hearing. Yes, Mr. Abedin. Wait, ready to give here. Okay.
I leave it to your lordship. Considering the hectic day and the timing also. But incidentally, I had the first item, so I'm here. No, it's a reminder because I always get this that I'll never appear in the first case.
So from today onwards, no Tagida. Okay.
If your lordship prefer to keep it as a judgment reserved, then also it can be. Because
Monday dia. Itu dispose the idea. Monday ada dia. This will, because I'll require your assistance.
Then have it Tuesday.
Tuesday dia. Itu Tuesday.
Tuesday mar asa nahi kiya. What ko say lo?
To Monday dia. No, no, you know about Monday. Aru kiba ase? Yes, done.
Tuesday. Tuesday.
Tuesday first item, my lord.
My lord, first item, if possible.
I'll dictate this only subject to some top of the list matters. Thereafter I'll immediately dictate. I'll not go for admissions.
It's okay. Deeply obliged.
Due to no positive of time, will you 43 কি কিমান আছে আৰু 43 কি আছে 62 এটা কাম কৰ as agreed to by the Learned Counsel এটা ডেট দি দিবা আগতে